Thank you for your patience as we were a bit delayed. Today, we actually began our morning at 8, knowing that this morning's agenda would be quite long, and it still went that long. So again, thank you for your patience. All of the issues are important. We'll give each of them their due time. And with that, we have a full board present, and I'll call item number 1.
Item number 1 is staff emergency items, and I'm unaware of any staff emergency items today.
Item number 2.
Item number 2 is changes, postponements, and notice of the next meeting. I'm unaware of any changes or postponements, and the next meeting will be April 25th at 9:00 a.m. at Manitou Springs City Hall.
And item number 3.
Item number 3 is public comment on items not scheduled on the agenda. This is the public's opportunity to comment on an item not scheduled on today's agenda. And Madam Chair, I wasn't able to see if anyone signed in for public comment.
Okay. Do we have anyone here to speak on any item that is not on the agenda? Excellent. If you all want to kind of queue up, you'll each have 3 minutes and introduce yourself for the record, and we'd love to hear from you.
Got it. My name is Catherine Chukas. I'm a 13-year resident of Colorado Springs, and I want to thank you for the opportunity to give public comment on an issue in my neighborhood just up the road from me on the northwest side of Colorado Springs. As some of you may know, West Woodman Road and the area south of the Air Force Academy is a blend of city and county land. It's been that way for a long time. Some of you may remember the dairy fire over there long ago. That happened in the backyard of my prior home on the northwest side. And there's a long history of this land not being incorporated into the city. And it makes it a really unique and probably unlike other planning situations this commission will encounter for lands elsewhere in the county. There's a proposal that may go on the County Planning Commission, onto the County Planning Commission soon about a telecommunications project at 1615 Cedar Valley Lane. It is on county land, but it is not in the city boundary. However, the actual construction of the towers will be within 50 feet of the city boundary. What we're talking about is a small piece of land between city neighborhoods informally known as Hunters Point and Woodstone and Peregrine, and then county land. The reason the telecommunication company wants to put this investment is for the benefit of city residents. They are not going to be putting up equipment and towers to serve the 5 county homes on Cedar Valley Lane. It is for the 5,000 residents in the neighborhoods I just mentioned. The impact on how this will be placed on this property will be impacting city residents who abut this property. And I would encourage this commission to be aware of the 1615 Cedar Valley Lane project and realize that a company is trying to do something a little bit invasive. And because of that, I'd encourage you to determine how to get city standards and city codes involved in this process, because the construction is 50 feet from the city boundary. This is city land that there's probably city land that the telecommunications company could have selected, but they didn't. It feels like they're trying to use an exception. I don't know where else to give advice about where to go, but I'd encourage this commission to consider how to involve city planning in this site and not to approve this without having the city of Colorado Springs involved. And if there's any guidance you'd like to provide my neighbors about how to proceed, that would be extremely valuable. Thank you.
Thank you very much. Anyone else wishing to speak? State your name for the record, and you'll have 3 minutes.
Colin Henry. I don't know how to do this, but I'm just donating my time to Tom. So is that possible?
Great.
Thank you.
Actually, for items not scheduled on the agenda, we don't generally do that. You're welcome to speak your best to it.
Colin Henry. I live at 1570 Mount Woodman Court. My wife and I, we're in the same neighborhood as the statement just made. Just general opposition for the cell phone tower. I guess there's 3 towers being proposed as opposed to 1. And we've got a subject matter kind of expert who used to conceal these things, and he said it's very typical to have 1 tower, not 3. So that's the only other thing I'll add. Thank you so much.
Thank you very much. Anyone else?
Good afternoon, board members. I can do this in French, but you probably won't understand me. My name is Denis Prévost. I live in Strathmore Valley, South. I discovered on my lot, I took the pin where it was at the end of the lot, and I measured 100 feet. I'm 6 feet on Burnham Street. all of the lots on the subdivision are like that. They've never been inspected by the planning board. I talked to the planning board, they don't want to talk to me. They refuse to put my name on the agenda. I said, this is nonsense. Oh, he said, you have to go see a lawyer and a land surveyor. For what? It's not my mistake. It's the planning board mistake. It was never inspected. There's a right-of-way between the two properties, and the properties go back to back. There's no pin that tells us where that line is. This is unacceptable. Unacceptable. For the county to have allowed that since 1962 when it was built for Fort Carson. And this is a hidden vice on those lots. All the sales that were done are all done illegally. And nothing has been done yet for that. I'm very upset. I'm a disabled. I've been there for 25 years. I don't need this. So I need direction. Either I go see a lawyer and create a goddamn lawsuit, which I don't want to do. I want to solve this on a friendly basis if I can. But I'm good at the legal. I won all my court cases. I'm not afraid of that.
Thank you, sir. Can you make sure that you,
I have the map here also for you guys if you want to see it.
okay,
color
thank
for you
you.
guys.
I think our planning director will make sure she has your contact information and we will follow up.
Who's going to follow up? She will?
Miss
right.
Megan.
Here's the map. Oh,
Yeah.
yeah, thank you very much.
Thank
for
you, sir.
listening to me.
Thanks for taking your time to be down here
I'll
today.
be back if I don't get what I
Make
want.
sure we have her contact information.
Thank you very much, sir.
Thank you. Is there anyone else wishing to speak on an item not on the agenda?
Hi, I'm Patricia Mohan. My husband, Tom Mohan, spoke this morning. So I'm speaking on behalf of the project that is 1650 Cedar Valley Lane. A few things of concern. I have had some back and forth correspondence with the gentleman who originally sent us that certified letter. Throughout the document, an additional document that he sent to me that we did not get originally, it's the letter of intent. And throughout the document, it uses verbiage special use review application. And he shared with me that when I asked who received this review application, which is very lengthy and complete detail of the project, that his team completed an early assistance meeting with the El Paso County Planning meeting on March 2nd. And again, we were notified on April 10th. So this was all already in the works without ever letting very close proximity neighbors know what was in the works. So that is very alarming. Let's see. There is another thing that I found pretty interesting that gives pictures of the actual site looking north, south, east, and west. And when you look south, this is our children's fort that sits about 60 feet from where these cell towers are supposed to go, which is very alarming and disturbing. They mentioned in here as to why they picked this area, which again seems a bit crazy. Said that it'll keep trespassers away and, you know, it's no harm to animals or anything like that. But we actually hike to the top of this ridge often, and there's no indication of any fencing that's going to be taking place either. So that's a concern. And sorry, there's a couple other things. They mentioned that this proposed location has been very carefully selected to create the least visually impactful, which is incorrect because myself and all the people that are here would actually see these god-awful towers that are fake-looking trees. And I think if there's something else. Oh, I guess at the end too, which basically falls under the special use review criteria. 1 through 7 is whatever the special use criteria language is that they would need. They answer true to everything. Again, we have been not given any time to try to review this to make sure that it is in fact true. All their answers are true and how they prepared. Because I can already see 3 on here that are actually very untrue. So we are very much in opposition, and thankfully a handful of our neighbors are here with us today. But there are at least 100 people that are in disagreement with this project. So
Okay,
that's it.
thank
Thank
you.
you.
Thanks for being here today.
Just for the record, the early assistance meeting is fairly common. You have those with the people who are submitting the project. And then when they do file the project, that is when they're required to notify the neighbors. Then you'll have a full planning commission process. You have the full, any of the comments that you've stated here today, we want to make sure that you submit them to the file at the planning department. And then it should, if I'm correct, Justin, go in front of the planning commission first, and then it comes in front of us. So those are all questions. You will not be denied your opportunity to speak in front of this body about the project on any of those intents for the permit.
Thank you for that clarification. I was actually going to make the same one. Commissioner Geithner.
Thank you. I just wanted to clarify a little bit further that because of the nature of hearings, what we are allowed to consider when we are looking at a project, and I think Commissioner Williams made this clear, but anyone can submit a project to go through the process, and then there are opportunities for everyone to weigh in on that process. But your comments today cannot be considered because they have to be within that hearing. So I just want to make sure you know that we're happy to hear you today, but if you want what you have to say on this item to be considered for that item, please do make sure that you either attend or submit something in writing, because we can't consider things outside of that hearing in our decision making.
Can I ask a quick clarifying question about that? In regards to that hearing, when that gets scheduled or when that will occur, how will we be notified or be aware of the occurrence of that and the preparation to do so?
Actually, can we have you state your name and sign in so we have your contact
Yes,
information?
absolutely.
But we're actually looking at some changes to that process that will be more expansive, but our planning director can answer those questions. And for the good of everyone in the room, would you mind letting me put you on the spot a bit?
Absolutely.
Thank
Good
you.
afternoon, Commissioners. I'm Megan Harrington, the Planning Director for El Paso County. This application for the cell tower is under review by county planning staff. It is in the very initial process. When the application does move to the public hearing, we notice citizens surrounding property owners. We are working on a new buffer, as you all know, between 200 and 500 feet from the property lines. And so we will send a notification, we will post posters on the property, and then anyone that contacts the planner will add that to a notification list.
Commissioner Vanderwerf.
Yes, thank you, Madam Chair. And I appreciate your input. And just for the folks that have testified about this morning and also this afternoon, whether if they're an adjacent landowner, they're likely to get that notice, but if they might be just close but not adjacent, I think if you have their contact information, would you also be willing to send them a notice?
Yes, sir.
if they're
For
asking?
every, typically neighbors will communicate with us via email. And when we receive your email, what we will do is we can add that to a notification list, an email notification list. So if you're not within the mailed buffer, you would then be on a list for receiving email. And all of the information that's associated with the application now, and as it moves through the review process, will be posted online. So I would encourage everyone to reach out to the planning department and to the case planner, and then he can get the information on that list, show the citizens how to work EDARP, which is our online processing system, so that they can follow the project through the process.
What is your email address, the general one? Is it planning?
Is it
PCD hearings.
Is it planning? I'm going to recruit Justin just to make sure that I don't get it incorrect. Thanks, Justin.
Good evening, Commissioners. Our primary email address, the one that gets checked constantly, 100 times a day, is DSD, that's Delta Sierra Delta, dash POD, Papa Oscar Delta, at elpasoco.com. And somebody is constantly checking that email address.
Thank you. Does that answer your questions? Did you want to use your 3 minutes to comment, or are you good? Okay. Please state your name for the record.
And just also for the record, all of our commissioner addresses are online, so if you send it to us, it also gets sent over there.
Okay, thank you. I appreciate it. My name's Allegra Henry. I live at 1570 Mount Woodman Court. I am a neighbor to this proposed project, and like you stated, I am not adjacent to the lot, so I was not notified. I am 2 houses over from where that notification occurred. We have a variety of concerns and areas that we would want to be considered by this commission, planning, zoning, all of those things. But we'll go through the process to make sure that those people are alerted and notified of our concerns. Some of those concerns that I'd like to state here, though, for today is, like my husband mentioned, they're proposing 3 towers, not 1. And those 3 towers would be on the top of a hill within view of multiple neighborhoods. However, the location that they are proposing to put this is a 1/4 mile away from where the initial desired search was for. The reason that they can't put it where that initial desired search was to happen was because of the zoning and all of this being residential area. We are all residential area, not just a 1/4 mile on a hill that is on the opposite side of where Verizon is saying that there's a dead zone. I am a Verizon customer. When I had a series of call drops, I called Verizon specifically, and they said it was because I was being deprioritized, because I wasn't a highest paying customer. I'm fortunate enough that my work is able to pay for part of my cell phone bill. Since paying more for my cell phone bill, I have not experienced any dropped calls. This is not a need for our area. Verizon is saying that there's a gap in coverage. There's not. They have sufficient coverage because I have not experienced any dropped calls since upping my payment plan. Also, Xfinity has in the ground cables, which provide internet service that is more than sufficient to handle all of my work from home calls, emails, Zooming constantly. I have no connectivity issues where I live. I'm in the middle of a valley, right in this very hilly area of town. So as a part of District 3, thank you, Commissioner, for your service. We specifically ask that you adhere that this is concerning for so many reasons. Property values could be devalued by up to 20 to 30%. Research proves that where these towers are placed. This is a residential area that is not zoned for commercial use. It's not zoned specifically for towers, telecommunications, anything like that. They're requesting a special use permit, and we'd ask that that be denied. And we'd ask for plenty of time to have this process be thoroughly vetted and for us to be able to show our opposition as a united front, as a neighborhood that does not want this project at the top of our hill. Thank you.
Thank you. Is there anyone else who would like to speak on any item not on the agenda? Okay, any online? And hearing none, we will move to item number 4.
Item number 4 is the land use consent calendar consisting of items 4A through 4D.
Are there any members of the public wishing to speak on items 4A through 4D? Any online? Okay, I'll bring it up here for comments and a motion.
I move approval of items 4A through 4D.
Second.
That has been moved and seconded. I'll call the roll. Commissioner Williams.
Aye.
Commissioner Vanderwerf.
Aye.
Commissioner Gonzalez.
Aye.
Commissioner Geithner.
Aye.
And the chair votes aye. The consent calendar passes 5-0. Item number 5.
Item number 5 is the called up consent calendar, and there are no items called up.
Item number 6.
Item number 6 is a variance of use, Ford Drive additional dwelling unit A request by Vertex Consulting Services for approval of a variance of use to convert an existing accessory living quarter into a second dwelling in the RR 2.5 Residential Rural District. The 2.89 acre property is located at the southwest corner of the intersection of Ford Drive and Millam Road. The Planning Commission recommended approval 8-1 for the variance of use. Concerns were noted by the dissenting Planning Commission member about why this was being switched from an accessory living quarter to an accessory dwelling unit. Parcel number 621400026, Commissioner District 1, file VA 23001, Christian Hayes, Planner 1, Planning and Community Development.
Good afternoon, Commissioners, Madam Chair. Thank you for your time. My name is Christian Haas, Planner 1 with El Paso County. This is a variance of use 23-001 to convert an accessory living quarters at 4775 Ford Drive to a second dwelling unit. The review team was myself and Carlos Hernandez, Engineer 1, who is in the audience today. If you're watching remotely and you would like to participate, please email a reliable phone number to pcdhearings@elpasoco.com. The request is by Vertex Consulting Services for approval of a variance to allow for a second dwelling unit on a RR 2.5 residential district lot. The 2.89 acre property is located on the southwest corner of the intersection of Ford Drive and Millam Road. And here's an aerial vicinity map. It's in the Black Forest area. It's a bit of background. The original 984 square foot dwelling was converted to an accessory living quarters upon the approval of a site plan for a new dwelling unit, a new single family dwelling unit in August in 2022. The property owners are now requesting that a variance of use be approved to convert the ALQ to a second dwelling. Now, there's some confusion about the difference between accessory living quarters and additional dwelling units. I'll refer to accessory living quarters as ALQs. The ALQ is intended for non-permanent guests. Typically, you would see like a mother-in-law suite where a family in need would come and live more or less permanently or non-permanently. The key here is unpaid, not rentable units. Dwelling units can be occupied by entire families. They can be rented out. And the difference here is important because the dwelling unit indicates a little bit more intensity of use. So more water usage, perhaps more traffic, et cetera. And so the county is pretty restrictive with additional dwelling units. In fact, they're only allowed in the A35 district by right. Any other district that wants a second dwelling on their property, which can be rented, would require this variance of use process. A review of the El Paso County Master Plan, because one of the criteria for approval is that this be more or less in conformance with the master plan. The place type is large lot residential, which supports rural character of the county while providing unique and desirable neighborhoods. Relevant to this request, the large lot residential place type generally supports accessory dwelling units when appropriate. A few of the goals, objectives, and strategies lifted straight from the master plan that seem to support the request would be land use goal 3, encourage a range of development types to support a variety of land uses. Objective housing and community 1-5, focus detached housing development in large lot residential and suburban areas, given the increasing infrastructure and environmental constraints with such development. And then strategy HC3, allow accessory dwelling units where appropriate as a tool to encourage more affordable housing, to increase the housing supply in a way that is a bit easier than developing on individual lots. And it even encourages the county to incentivize developing ADUs in wherever and whenever appropriate. The site is located within the Kettle Creek drainage basin. However, drainage and bridge fees are not assessed for variance of use applications. And there was no traffic impact study required for the application, but the applicant will be required to obtain any access permits if they do not currently exist on file. And it is subject to El Paso County Road Impact Fee Program. As we briefly heard, the Planning Commission voted 8-1 in support of the request. The dissenting member questioned the process employed and perhaps thought the variance of use should have been pursued at the initial phase of converting that original dwelling to an accessory dwelling. The applicant is present today and has a presentation for you. It's Vertex Consulting Services via Nina Ruiz, and the owner is Joshua and Catherine Patterson. And I'll leave you with the approval criteria for your review. It's located in section 5.34 of the Land Development Code.
And I'm going to pause you right there. I think Commissioner Geithner needs to make a statement.
Yes, thank you, Madam Chair. I do wish to make a statement that I know this owner. Actually, they are friends of my family's, and so I wanted to put that on the record here, that is the case, as is proper, but I feel that I can be fair and impartial in the decision-making today.
Commissioner Gonzalez.
Thank you, Madam Chair. So when this was originally approved in 2022,
Yes, sir.
what were the statements made as to the use of the family? What were they going to use when they converted to the main house? What was their stated use for the property, of the remaining property?
To be honest, I wasn't employed by the county at that time, so I'm not exactly comfortable speaking for them. I'm sure the applicant will be able to probably offer a little bit more insight.
I'd
into
like to
that.
hear that from someone from staff, what the statements were.
You mean statements from the property owner as to what they're going to use the...
Back when it was approved, when they were asking for the building of the new site and then the conversion of what was originally the primary home to ADUs, they must have stated something back then.
Commissioners, for the record, Megan Harrington, Planning Director. Commissioner Gonzalez, we had quite a bit of turnover in the planning department in the last year, and I'm not sure that there's a staff member here that can specify. Okay, apparently Carrie is the, come on up. I can tell you that they did sign the ALQ waiver and the statement on how they were going to use the property, but I will let Carrie fill in for the ADU process specifically.
Carrie Parsons with Planning and Community Development. Good afternoon, Commissioners. It is standard practice that if an applicant should approach the front counter or call the Planning and Community Development Department and talk to a planner of the day, and they request to construct an accessory living quarter that meets the requirements, such as being smaller than 1,800 square feet, they agree not to rent that home out. They can begin constructing their dream home, in this case, what will now be the principal home, and staff would encourage that. And then if later down the road an applicant changes their mind due to a financial circumstance or just a change of heart, the applicant then can obtain a variance of use permit if it is approved by this body for that second dwelling to modify the use from an accessory living quarters, which was also known as a guest house back before we modified our code a couple of years back from a nomenclature change. And that is why they're before you today. So based on that standard practice at the Planning and Community Development Department over the years, it's right in line with go ahead, build your dream home. This now becomes your accessory living quarters or your guest house. And then if you should choose to rent that in the future, a variance of use would be required to be approved by the Board of County Commissioners.
Thank you for that clarification.
And there is a note in our early assistance in EDARP, our electronic system, that does specifically state when the early assistance meeting was had, it was guest house. And that's the extent of the notes, was being used as a guest house.
Thank you. Do you have anything else for the staff presentation? Okay.
Thank you.
Okay, thank you. And is the applicant available?
Thank you. Nina Reese with Vertex, representing the owner. As I pull up my presentation, see where it is. There it is. I I would like to address the question about the use, even though I think we can all recognize that's not a review criteria. So it's not a reason for approval or denial, but since it continues to come up, I thought I would just address that. So within the Land Development Code, as was stated, you can have an accessory living quarters for guests for temporary occasional stays, so not permanent habitation, even if it is by family members. That's just a use by right, if you sign the affidavit and have that recorded. Mr. Patterson came to the front counter and was attempting to obtain a building permit for his second dwelling. And at that time, he spoke with Dennis Archuleta at the front counter and was told, well, you can do that, just sign this affidavit. At that time, it wasn't discussed that there was a variance of use option, which is fine because that's standard practice, and it would only be if an applicant told Planning and Community Development that that was their desire, that anybody would go through the variance of use process and explain the various options there. So hopefully that addresses that question. It wasn't Mr. Patterson trying to be sneaky or trying to do anything out of order. He just simply didn't know that that was an option. So later on, he found out from talking with staff after one of the Planning Commission hearings, is what I understand, that a variance of use was an option, and then he started pursuing that avenue. Are there any questions on just the background and how the structure came to be constructed?
No questions.
Thank you. So many of the slides were already covered, so I'm going to kind of skip around a little bit. So again, just to point out, this is the existing single-family residence that was constructed in 1960, and it's 984 square feet. This is the new structure that was permitted and is in excess of, obviously, the 1,500 square feet that's allowed by code for a second unit. There are two distinct access points that have been permitted. So one access point is to the north and the other access point is to the south. The property owner did that to kind of try to divide the traffic so that there weren't impacts on one single roadway. The background was already covered, so I'm going to skip over that. And then the review criteria that I'll focus on, because I will do an abbreviated presentation, because I know that there's quite a few people here today. I'll just focus on the first three review criteria, and then I'll just very, very quickly go over the others. So air, water, noise. This is a single-family residence, so we're not anticipating any significant impacts. The applicant has already started the approval process with the state to allow for their well to be utilized for 2 dwelling units. They've already initiated that and have a water attorney on board. They are prepared and are meeting all requirements of the county, state, and federal regulations. There are no impacts to wildlife and wetlands because the structures are existing, so there's no additional new impacts. The very minimal off-site impacts that are anticipated would be that 10 average daily trips, and that's minimal as well. And they have mitigated that impact by having 2 different access points, so divided that traffic. The site plan that's on file demonstrates that the site meets all of the parking, traffic, circulation requirements. Because this is single family, there are no specific requirements for open space, fencing, screening, or landscaping. And then lastly, they do have an existing septic permit that's on file that's been permitted for the second dwelling, and they're meeting all stormwater, fire protection, and police protection as well. So I'm just going to very quickly go over the first 3 criteria here. So the third criteria has to do with compatibility with the surrounding area and harmonious with the character of the neighborhood. When I did a survey of, oh, looks like church popped over here too. There's not, oh no, there is another church right there, I'm sorry. When I did a survey of the area, I found that just to the north, there's a church, so that's somewhat of a commercial use. And then there's also 5 properties within half a mile that actually have 2 dwelling units. So it is absolutely within the character of the neighborhood for there to be 2 dwelling units on a single piece of property. Looking at criteria 2, which is in compliance with the master plan. This is within the forested key area. The applicant is meeting and adheres to all transportation, stormwater, built form, and transition guidelines as identified within the master plan. This is also within the minimal change undeveloped area of change, and that area of change specifically identifies that underutilized properties can be redeveloped as long as it does not alter the character of the neighborhood. So because the character of the neighborhood is that there's more than 2 dwelling units on many properties, we do not feel as though it's altering the character of the neighborhood. It's within the large lot residential place type. Christian did cover that the master plan supports accessory dwelling units, so I won't beat that too much, but I do just want to point this out. So within the housing and communities section that he identified, not only does it promote accessory dwelling units, so not accessory living quarters, this is the purely second dwelling on a single piece of property, but it also states to proactively promote the construction of ADUs, and they can take numerous forms, including fee waivers, pre-approved unit plans, assistance navigating the permitting process, and even going as far as recommending working with lenders. So the master plan goes above and beyond to support ADUs within the county as a whole and this specific place type. Criteria 2 is, I'm going to skip over that because Christian did that. Criteria 1, so strict application of the code would result in a peculiar and exceptional practical difficulty or hardship. So the only other option beyond doing a variance of use would be to rezone this property to multifamily, which would be 12 dwelling units per acre. I think we can all agree that that would not be consistent or compatible with the surrounding neighborhood. The land development code may be outdated. There have been 7 variance of use requests for second dwelling units within the last 5 years, and that represents 1/6 of the total variance of use requests and approvals within that time frame. So it appears as though there continues to be a trend towards having accessory dwelling units, and the master plan also supports and promotes having accessory dwelling units. So I know that there are many other items on the agenda today, so I made it real quick. Are there any questions?
Are there any questions for the applicant?
Okay, thank you.
Anyone? Thank you. Okay, at this point, is there any more from staff? Okay, we will start with, are there any members of the public in support of this application, this request? Okay, any online? Okay, hearing none. Are there any in opposition to this application? Okay. All right. At this point, please proceed towards the microphone, introduce yourself, and you'll have 3 minutes.
If Nancy could bring up the slide that I have. Terry Stoka, Black Forest Land Use Committee. We feel that the county has been very generous to allow accessory dwelling units for the purpose of family members, elderly parents, things like that. And we're not even opposed to the idea of a guest house, something that you have relatives come and stay on and off. That's something that's reasonable. But what we're opposed to is a permanent dwelling, because we feel that that goes beyond what this is talking about here. And as you know, that prohibits collecting rent at an accessory dwelling unit. Approving 2 dwelling units on this acreage, which is only 2.89 acres, is a violation of both the Land Development Code and the county master plan. It effectively creates a subdivision. It creates 2 separate lots almost, because you have 2 separate homes. One is going to be income generating, and the other was going to be the living quarters. The master plan states a minimum density of 2.5 acres per lot in this area. There's no open space, there's no compatibility. Yes, there are other accessory dwelling units in the area, but I would question and ask the question, are they accessory that are for elderly parents, guest house, or is it something that's a permanent structure, not a permanent structure, but a permanent arrangement of a lease or a rental? I don't know the answer to that question, even though there are some accessory dwelling units in the area. We believe this sets a dangerous precedent for allowing how many people are going to want to divide up their property and have a second house that they can rent out. It violates the zoning. It is not going to create open space. People are going to do it simply for the purpose of creating more income. So this is really not in conformance with the master plan. It is not in conformance. It violates the land development code. And we feel this is not wise to approve this, and we recommend that this variance not be approved. Questions?
Thank you, sir.
Thank you.
Is there anyone else wishing to speak in opposition? If you could come forward. Did we have anybody else raise their hand in opposition to this? Did you want to speak? Okay. Okay, anyone else wishing to speak in opposition to this? Okay. Would the applicant like to address any of the things brought up?
Thank you. I would like to very quickly address the comments that Mr. Stoka had. So it is not out of compliance with the master plan. So the master plan for large lot residential, it does identify 2.5 acres as being recommended, but along with that, it specifically identifies that accessory dwelling units are recommended. So they're saying minimum lot size 2.5 acres with accessory dwelling units. So it's in full compliance with the master plan.
Okay.
And I know that there's no precedent when it comes to land use, but there are, maybe the precedent has already been set if that's going to be stated, because there's 5 properties within half a mile that have 2 dwelling units on them already.
Commissioner Gonzalez.
My question, because you brought it up, was the 5 properties. Do you know if any of those are being rented or
Yeah.
not? And okay.
Yeah, so I can tell you based upon the land use approvals, which ones are allowed as 2 dwellings versus it being just for family members. So this one right here would allow for rental. This one right here would allow for rental. And then this one right here would also allow for rental. So 3 of the 5 could be utilized for rental. The other 2 would be for family members.
Any other questions?
I just have one. What is the acreage of the proposed site, your blue property?
So the property is 2.89 acres.
Okay, thank you.
Any other questions? Okay, at this point, we'll declare the public hearing portion of this closed. Any discussion from commissioners? Commissioner Gonzalez.
Thank you, Madam Chair. So on this one, yeah, if this was the first one, I'd probably be more inclined to disapprove, as there are already other examples utilizing the same. I'll be able to support.
No, as the resident commissioner, I agree with Commissioner Gonzalez, and so I would move approval of this item with any proposed notations and conditions set forth in the resolution. 3 conditions and 3 notations. Thank you.
Is there a second?
I'll second.
Okay. Item number 6 has been moved and seconded for approval. Commissioner Williams.
Aye.
Commissioner Vanderwerf.
Aye.
Commissioner Gonzalez.
Aye.
Commissioner Geithner.
Aye.
And the chair votes aye. Item number 6 passes 5-0. can I get a show of hands before we move on to the next one? How many people are here for item number 7 and then item number 8? Okay. No. Item number 7? Okay. And then item number 8? Okay. With that, I think we'll proceed through item number 7 and then take a brief break before item number 8 again. So item number 7.
Item number 7, sketch plan, Jane's sketch plan, a request by Classic Communities for approval of a sketch plan consisting of a maximum of 450 single-family residential lots, 101 acres, approximately 4.5 acres of commercial, 13.7 acres of future right-of-way, and approximately 22.9 acres of open space. The 142.1 acre property is zoned RR5, residential rural, and is located at the southwest corner of Volmer Road and Poco Road. There is opposition to the requested plan, which includes increased density and traffic to area, water supply, and loss of habitat. Applicant has made minor changes to the sketch plan post the Planning Commission approval 8-1. Parcel numbers 522-80-00-024 and 025. Commissioner District Number 2, file SKP 22005, continued from March 21st, 2023. Carrie Parsons, Senior Planner, Planning and Community Development.
Ms. Parsons.
Thank you. Give it a minute to catch up here. Carrie Parsons with Planning and Community Development. While the PowerPoint is catching up with us, I just would like to remind the board, I believe Jackie mentioned it, this item was originally heard at the Planning Commission. It was denied at the Planning Commission. It then moved forward to the Board of County Commissioners. There was no hearing at that time. The Board of County Commissioners did continue the item to this date as a certain date and requested that the applicant do go back to the Planning Commission with those revisions recommended by the Planning Commission. The applicant did follow the board's advice. Sorry, I combined advice and guidance together, and I got advice. They did go to the Planning Commission, where they did receive an approval to further kind of confuse the issue. At both Planning Commission hearings, the Planning Commissions did make recommendations to make changes to the sketch plan. So at the Planning Commission's first hearing, changes were made after the fact. And then again, at the second Planning Commission hearing, there were some minor changes also made after that Planning Commission. And those are identified in your memorandums for today. Just wanted to clarify that because it is kind of confusing. Review team, myself and Mr. Rice with DPW. If there are any of those folks that are watching, if you could please go ahead and email the address on your screen, we'll get you in the queue for the hearing. I'd like to identify the first step of the subdivision approval process for those in the audience. The subdivision approval process can be a multi-step process for large, complicated development. We would anticipate a sketch plan. A sketch plan would be coming to the Planning Commission and the Board of County Commissioners. If that sketch plan were approved, it would then, the next step would be a rezone or a map amendment, and then a preliminary plan, and then a final plat. The sketch plan is intended to set land use to land use compatibility, major access points, and overall densities. It does not address water sufficiency, internal roadways, just those major roadway connections. And in this case, we're going to talk a little bit about the Stapleton Road corridor and Volmer Road. The approval criteria, as stated on the slideshow, and I won't read them verbatim, but I'll give you enough time to read, and then I'll advance the slide. Thank you. Specifically, this is a request by Classic Communities for approval of the Janes sketch plan. The maximum density is 450 single-family residential lots on approximately 101 acres. That density has not increased with the changes made after either planning commission. It has remained the same. There's an anticipated 4.5 acres of commercial development located at the nodes for the major intersections, and about 13.7 acres of future right-of-way, and 23 acres of open space throughout the sketch plan. Currently, the property is zoned rural residential 5 acres, and it, as I mentioned before, it is located west of Vollmer Road, south of Poco Road, and north of Woodman Road. Zoning map of the area, again, that Briargate corridor, Stapleton, cutting it right in half, and then we would potentially see that connecting further to the west into the city of Colorado Springs, the Janes plan here. Adjacent to the Janes to the east is the Homestead North developments. Further to the north, Retreat at Timber Ridge, all those classic developments. Below Briargate Parkway, east of Vollmer, still within the Sterling Ranch overall development. We have a node of commercial right there at the southeastern corner of what will be Briargate, Vollmer, and Wheatland is this little road right here. The developed single-family homestead South, and then we also have branding iron developments all existing and built out. Planning Commission summary, I kind of went over this, but back in February, there was a denial vote of 5-3 due to the lack of sufficient transition at the northern boundary adjacent to Poco Road. There was also comments on that western boundary transition. There were community concerns, which were density, transition, traffic, loss of undeveloped land, natural features, demands on education facilities within District 20, and concerns related to water availability. The community concerns, for the most part, have not changed. However, the Planning Commission comments have changed. At the Planning Commission hearing, as I mentioned, there was comments to modify the lots at the northern boundary along Poco from the half acres that were originally depicted in the initial sketch plan submittal to the 2.5 acres, and that is what the applicant agreed to. The western boundary lots are now 0.7 after the second Planning Commission hearing, where they were originally presented to the second Planning Commission as half-acre lots. Additionally, the setback was increased at the second Planning Commission from 75 feet to 85 feet, which was consistent with what was originally presented at the first Planning Commission hearing, was the 85 feet. Any questions on the differences between the Planning Commission hearings for the record? Okay, this is a quick look at the sketch plan. So here, Poco Road, and excuse me, north is now to the west in this drawing, so we could fit it on the screen. Vollmer Road here, Stapleton Corridor. So you can see the applicant has now provided 2.5 acre lots along Poco. We anticipate a maximum of 6 lots there, including the existing homes that is there. It will be platted as a lot. This is known as the Smith parcel. It is not included in the Janes sketch plan. This was one of the revisions that occurred at the second Planning Commission, where the applicant agreed to go from a half-acre lot there to a 3/4 acre lot. And then on the western boundary here to the south of your screen, we have the 0.7 acre lots and have increased that per the Planning Commission comments at the second hearing to 85 feet. Any questions on that drawing or slide? In terms of the master plan place type, this area is within that suburban residential place type. We would anticipate that the primary use and lot size will be lots for single family residential use, less than 2.5 acres in size. So in general, the applicant's sketch plan is consistent with the place type. The place type also identifies supporting land uses such as multifamily and commercial at specific nodes. The area is also within the area of change new development. This entire area on west of Vollmer and east of Vollmer within the Sterling Ranch sketch plan area is expected to significantly change in character with new development. The area is also identified as the master plan as a key area of potential for annexation. However, the applicants choose not to annex into the city. Although county staff and city staff and the applicants are coordinating for the road construction for the Stapleton corridor as well as drainage, and that will continue throughout the land development process all the way up to those construction drawings that will be submitted with the final plat applications if the sketch plan and subsequent zoning applications were approved by this body. It is also within the priority development area, specifically the Falcon area. The Falcon area is anticipated to have suburban residential development to match the existing developments in Colorado Springs, which is adjacent to the west and further to the south of the area. There was emphasis specifically that the county should support completion of the Stapleton Road to improve connectivity between the Falcon area of the county and the city of Colorado Springs. So this sketch plan, staff did find that it was consistent with the priority development area of the master plan. Some of the highlighted goals and objectives that the master plan, I won't read these, they're in your staff report, but I just want to point out a couple that are, I think, most important. Goal 1.3, to encourage a range of development types to support a variety of land uses. So within the sketch plan, we have rural lots at 2.5 acres, and then we have urban densities that are proposed anywhere from 5 to 15 dwelling units per acre at the central portion of the sketch plan. There is also identified a commercial node at the anticipated corridor, and then there's also other open space areas and pedestrian connectivity. The other thing I want to point out for the master plan goals and objectives is objective TM1-4, which encourages sidewalks and other multimodal facilities in all development and place types as appropriate, and upgrading existing infrastructure to these types of facilities when maintenance is needed. So again, that sketch plan does identify those pedestrian and multimodal corridors, and then as the development progresses through rezoning and preliminary plans, staff will continue to work with the applicants if the sketch plan is approved to identify sidewalks that connect to those regional trail corridors and other trail corridors within the sketch plan area. Are there any questions on the master plan and how it relates to the Janes sketch plan? Okay, in terms of the water master plan, the sketch plan area is within Region 3, which is the Falcon area. As noted previously, water sufficiency is not identified with the sketch plan approval. However, water feasibility is a component of the approval criteria with the sketch plan. And so what does that mean? What that really means is that the applicant is required to submit a water resources report to Planning and Community Development, which identifies how much water they have now and how much water they're going to have to obtain and how they're going to obtain it to get from the sketch plan to those specific final plats. The applicant has provided that documentation, and it is available in EDARB in the project file. I think I've covered everything here. I don't want to repeat myself because I know it's been a long day. I think last thing I would like to state is that both the Black Forest Fire Protection District and Academy School District 20 have not objected and are continuing to work with the applicants. It is anticipated that across the development area from Vollmer, the Sterling Ranch development will have 2 new school sites very shortly for Academy District 20, and this development then would be able to use those school sites, and this development will end up paying school fees at the time of plat recording in lieu of dedicating school land. Are there any other questions for staff on planning items? With permission, Chair, I'd like to ask Mr. Rice to come up and talk about the specific engineering for the project.
Afternoon, Commissioners. Jeff Rice with Engineering. There is no FEMA floodplain on the property. It is in Sand Creek Drainage Basin, and drainage and bridge fees would apply with final plats. There are 2 natural drainageways through the site currently that will be designed and have been accounted for in the Master Development Drainage Plan, which has been approved. Water quality and detention facilities will be provided as identified in the MDDP. And the ultimate discharge location for the flows go through Sterling Ranch to the east and into Sand Creek, which is just off-site, or kind of in the middle of Sterling Ranch to the east. There's an aerial overlay that shows the site, and then Sand Creek over here east of Vollmer, and there's Vollmer, and then the Briargate Parkway connection through the site. As far as transportation, the Master Traffic Impact Study estimates that the development will generate approximately 5,500 to 6,000 trips, being conservative. And then upon build-out, signalization of Briargate Parkway at Vollmer Road and site access road intersections may be warranted. So as development progresses along with Sterling Ranch, those are analyzed at each step of development. The sketch plan does show conceptual access points, and they're based on revisions with the 2.5-acre lots along Poco Road. There would be individual driveways to Poco Road. One of those homes exists already, so there'd be 5 additional accesses onto Poco Road. And the development will be subject to the El Paso County Road Fee Program. Anything for engineering?
Any questions?
Okay, thank you.
Thank you.
One unique condition to this sketch plan is on your screen, condition number 3, and then notation number 2. It's very specific. Are there any questions on the specific conditions that staff is recommending that the board approve?
Any questions on this condition and notation? Okay.
Thank you. Okay, with permission, Chair, I'd like to ask the applicant to come up and represent their application. Nancy, can I get OneDrive back up for the applicant's presentation, please? I think this one's you.
Good afternoon, Commissioners. Andrea Barlow with NES, representing the applicant.
Hold on one second. Let's get your mic working.
Is that better?
Yes.
Thank you.
Thank you.
Andrea Barlow from NES, representing the applicant. Well, I've lost my cursor. There it is. Okay. I was trying to use the cursor, but it was taken away from me. So, okay, here we go. So the site is located at the intersection of future Briargate Parkway and Vollmer Road, either side, north and south, and south of Poco Road. It's 142 acres, and it lies west of Sterling Ranch, which is the currently developing area on the east side of Vollmer. And the property is currently zoned RR5, which is consistent with most of the existing undeveloped land in this area, including Sterling Ranch. The undeveloped parts of Sterling Ranch are all zoned RR5 as well. So it's fairly typical in this area for an RR5 zoning to exist prior to future development taking place. And the surrounding zoning, RR5 to the north and northwest, RR2.5 to the west, and then RR5 just to the southwest. And then on the east side, it very much changes character. We have some RS 6,000 zoning, so that's 6,000 square foot lot minimums, and RS 5,000 zoning with an area of commercial and some industrial uses as well. So I wanted to provide some context of what's actually effectively been approved in the area already. So to the west, as noted, you have Sterling Ranch sketch plan, which currently, based on the most recent revision to the sketch plan, which was 2022, is at 4,800 units. That was a reduction from the original approved sketch plan of about, I think it was 5,250 units. So there has been, with revisions, with plans moving forward, there has actually been a revision in the total number of units at Sterling Ranch. The retreat at Timber Ridge to the north there, that was approved subsequent to the Sterling Ranch sketch plan. So that has a mixture of rural residential lots of 2.5 acres and also some smaller lots, which are about 12,000 square feet on average on the east side of Sand Creek. To the east is the ranch development, which was approved by the board, a sketch plan a couple of years ago. And that has urban residential densities there. I'm going to talk a little bit more about that in the transitions. And then obviously to the west is Wolf Ranch in the city. And you can see that really between Wolf Ranch and Sterling Ranch and the Janes property, there are some rural residential lots, which are almost creating a little enclave there between city urban development and county urban development. An important factor there to point out is the Briargate Parkway connection. I actually have a better slide later to show you the more global aspects of these east-west connections. But I think what you can see there, if you can see the slide clearly enough, there is an area between the Janes property and Wolf Ranch, which is a dedicated right-of-way through the adjacent Highland Park subdivision. So that right-of-way has already been dedicated to the county. So that right-of-way to extend Briargate is already in place. So really, this is the missing link. There is also a small link between Sterling Ranch and the ranch. But Classic Homes owns that parcel there to make that link. So really, this is the last link in that ability to make the connection of Briargate Parkway through to the city. And as you know, but this is maybe a bit of a refresher for the members of the public in the audience, these roads are built by the developers, not by the county. So it is needed, the density to support the construction of these roads it needs to be at a certain level to warrant the cost of constructing these fairly substantial roadways. So I'm not going to dwell too much on some of the earlier plans, but just to provide some overall context, we had, this was our very first submittal to the county. We had buffers around the edge, and we had a range of densities starting at 1 unit per acre in the 1 to 3 units per acre in the pale yellow area, getting more dense as you got more to the center of the site. We also had a neighborhood park, which we ultimately moved, and I'll explain that later, but this was the first plan that was submitted. As Ms. Parsons mentioned, 450 units was always our density cap, and we haven't changed that. So we had a neighborhood meeting back in October. 32 people showed up, and here are some of their concerns. I think staff have already kind of identified what those were, so I won't reiterate those. We will be focusing primarily on transitions and density transitions and compatibility, a little bit on traffic and also natural features, but happy to answer any questions you have on any of the other matters. So we revised the sketch plan when we went to, between our initial submittal following the neighborhood meeting, to include some 1 acre lots. I just do want to correct, I think Ms. Parsons says 0.5 acre lots. It was a 1 acre lot density along that northern boundary that was presented to Planning Commission with, in the kind of pale, in the medium yellow color, it were 1/2 acre lots along the western boundary and wrapping around the property. So I do want to talk about the one property, the approximately 5 acre parcel that's what this project is wrapping around. That is owned by the Smiths. And we've had, the Classic Homes have had a lot of discussions with the Smiths over the period of this review of this project and post-planning commission, which I'll talk about a little bit more. So that property is obviously the one that's most affected by this development, and we've tried to take measures to address compatibility, particularly with that property. In addition here, as you can see, the park moved from more of the central part of the property to the edge. And the reason for that is there are some natural features in that area which were considered warranted protection. There is a small pond area. It's not a natural pond. It was created through the farming of the property, but it's a kind of a nice feature. And there's also some raptor nests in some of the pines along Volmore Road. So we moved that through discussions with our environmental consultant and staff to help to protect some of the natural features on the site. I will just go back and point out that we do have a community trail in this version of the plan along the boundary of the west boundary through the buffer area. And I just wanted to point that out because that's one of the changes we made. So this was, so I've explained these revisions. We also had in addition to the buffer, a 35-foot building setback, which is in the hatched area. That was incorporated to provide additional distance from the adjacent properties to the proposed properties on the periphery of the development. So we had a planning commission meeting back in February. 10 people spoke in opposition, concerns. There were a variety of concerns, but I think the primary concern was density transition. And also one gentleman who was in the neighborhood to the west wanted removal of the trail in that western boundary, was concerned about litter and just activity generally from the trail. We got a vote of 3 in favor, 5 in opposition at Planning Commission. And these are some of the comments that came back from the planning commissioners, were really a need for better transitions. A better transition to the north along Poco Road. They would prefer to see a 2.5-acre lot strip along Poco Road. And the point was made, and come back to this when we look at the master plan, that 2.5-acre lots are allowed in the suburban residential place type in the master plan. So that seemed a reasonable request in the context of the master plan designation, and also suggested we incorporate the buffer and the setback into the lot to make up that difference. Also suggested that we increase the density in the interior of the site, so in order to maintain the viability of the project and that 450-foot density cap. And also a request to increase the lots on the west boundary. That wasn't, I would say that was not a mutual concern amongst all the planning commissioners, and a couple kind of thought it needed addressing, others were fine with how we presented it. And everybody agreed that there was adequate transition on the east boundary to Volmore Road and Sterling Ranch. So I'm going to hedge this. This is not quite the currently proposed sketch plan. This is a sketch plan we presented to Planning Commission when we went back to Planning Commission. These changes we had made between Planning Commission and our initial visit to the board, but we decided that it would be better to go back to Planning Commission to present these changes. And we're happy that we did, because now we have a favourable vote on this plan of 8-1. The changes we made, as have already been noted, along the northern boundary, we changed that to 2.5-acre lots. Initially, and I'll come on to this a little bit more, we changed the lots along the south of the Smith property to 1/2-acre lots. And then we increased the size of the lots on the west boundary to 0.7 acres and had a 75-foot, change from 35-foot to 75-foot. We have since presented plan, and it really won't show up very clearly because it's 10 feet different, but we have presented a plan that now increases that to 85 feet. What the Planning Commission wanted was to achieve the equivalent of the combined buffer of 50 feet and 35 feet setback that we had previously, which of course adds up to 85 feet. So that is a change that we have now incorporated. And in exchange for that, in the orange areas, we increased our density slightly. So it was previously 5 to 12 units per acre. We're now showing 5 to 15 units per acre in that area. So I want to talk a little bit more about the relationship to the Smith property and also Poco Road generally. So as you can see, we changed to 2.5-acre lots along Poco Road. There is the existing Jane's property, which is kind of on the corner of Poco and Volmore Road. There is the existing Smith property, which is obviously not part of this property, but or this sketch plan. So really, we're just adding, our proposal would be to add 5 additional homes, if you think of it that way, homes along Poco Road. They would be serviced by well and septic and accessed off Poco. So the intent for these residential lots is that they will function as rural residential lots for compatibility with the rural residential to the north. So they will take lot access off Poco and will be served by well and septic, because they effectively now, and with the grading of the site, they are turning their back on the rest of the development. So it doesn't make any sense to try to service them from within the development, because there'll be limited grading on those properties, and it just doesn't work in the same way as it would have before if they had been smaller lots that could be incorporated into the overall development. I wanted to point out here that the circles that you see are the approximate building centrums based on topography again. And we are showing a minimum setback of just over 51 feet, which is greater than the setback of the existing buildings. The Smith barn is located closer to that, and similar distance to the existing Jane's property. So just generally, it's not bringing a lot of development onto Poco Road, fronting Poco Road. I also want to point out here that the distance of the Smith property, so you take it from the rear of the Smith property to the rear property line, is 370 feet. So they are very much at the front of their property. So there's quite some distance between their property and the edge of the development. And again, looking at this more from a cross-section point of view, there will be some grading on the property, and the proposed units will be located further south. So the lower elevation, when you start going further south, the elevation decreases. So the Smiths will be effectively looking over the top of the homes that are on the adjacent property. And just to clarify here, we did make a commitment at the hearing Planning Commission, and we changed the plan accordingly to commit to 2 rather than 3 half-acre lots along the south boundary of the Smith property, to change that to 2.75 acres. That's actually reflected in the new sketch plan. That was following discussions that Classic Homes had with the Smiths, and that was at their request, and also that they would be ranch restricted. So per that plan you saw, this plan doesn't show a ranch restricted property. It shows a regular 2-story home. So it would actually be set even lower than that. So with that, we feel that we have listened to the concerns of Planning Commission and the neighbours in terms of providing that more transitional density, and also really taken measures to respect what the Smiths have asked for along the way. I think they still would prefer this not to change, but when there is change proposed, these improvements have addressed some of their concerns. And one other thing I want to point out is they were previously concerned about the fact that the half-acre lots on the south boundary stopped right at their boundary, and how we changed that to ensure that it would not have higher density right next to them was extend further west that 0.75 acre area. So with that said, I want to provide a bit of context as to why we started where we started, and with the buffers that when we went to Planning Commission initially, because we were very much looking at what happened elsewhere in Sterling Ranch and the ranch. And I just want to briefly touch on this, in that you have on the south side of Sterling Ranch, where you have RR5 zone properties to the south, we have a 50-foot buffer, a 100-foot setback, and half-acre lots. So on the north side, we have buffers and half-acre lots against what was originally in the retreat at Timberidge RR5 zoning. It has subsequently moved to PUD with 2.5-acre lots and 12,000 square foot lots. And then on the east side, we also have a lot of RR5 zoning, and there was a range of residential densities there, including buffers. So in this sketch plan, we were not required to do 2.5-acre lots next to 5-acre zoning. But so in that regard, we feel we have gone over and above what has been set as a precedent elsewhere in this particular part of the county, which is an urbanizing, developing part of the county. Similarly with the ranch, which is a little bit further east, we had, you can see pretty much all the way around the property, RR5 zoning. The only non-RR5 zoning was in the northeast corner, which was RS 20,000 and RS 6,000, part of Paintbrush Hills. But in that context, we provided different buffering. On the east, there was a natural buffer. There is a 300-foot XL power line easement. But to the north, west corner and to the south, we then provided 1 acre lots with a buffer. So that was very similar to what we originally went forward with Planning Commission. So I do feel that we have moved an extra step with this plan to create that transition and buffering over and above, like I say, precedents that have been set with other plans in the area, which we worked on. So we were using that as our basis to suggest the plan that we originally suggested. So to the Met County Master Plan, I like to show this slide because I think it provides important context. Obviously, there's a substantial amount of growth anticipated in the county, and that growth is to be accommodated by new development areas in the county. So the master plan divided the whole county up into areas that were to be conserved, areas where there will be minimal change, and areas where there will be new development and transition. And so for the 90% of the county, nothing really much is intended to change. That 90% of the county's land area will remain generally minimally changed to accommodate this growth. So it's really important that in the areas that are designated as new development areas and transition areas, that growth is accommodated and the significant growth that the county is anticipating. So with that, this is a priority development area where the residential growth is anticipated to be accommodated and prioritized. It's part of the Falcon area, priority development area. And it's anticipated that density in this area will act as a transition and a buffer from the more dense residential development in the city and the less dense residential in the Black Forest forested areas. And with that, it is a new development area. So that's one of the 10%, or it's actually 9%, 1% was transition. This is part of the 10% of the county where development should be concentrated. So it's really important that the development is provided in these areas. And as you can see, that actually includes the area to the north of Poco Road as well. With regard to the suburban residential development designation, that is predominantly to accommodate single-family detached, and we anticipate that the Janes property will be predominantly that. There may be some attached product in some of those higher density areas, but as you can see, single-family attached is anticipated as a supporting land use, as long as it's not the predominant land use in these suburban residential place types. The range of densities starts at 2.5 acres up to 5 units per acre. So our 2.5 acre lots are consistent with the zoning, the designation in the master plan. And so we believe that all the factors, when you put these all together, the Janes property is a location that is to be emphasized for new development and significant new development at higher densities. So in regard to traffic, we did. I'll come on to the traffic reports shortly, but we in the traffic report we're looking to the future, and we're looking at how roads will be improved in the future, because the roads are being designed and improved to accommodate the significant new development that's happening in this area. And there's no way of kind of sugarcoating it. There is significant new development planned for this area. It has been planned for many, many years. And this, the yellow line you see here is the planned extension of Stapleton all the way through to Briargate and Briargate Parkway through Wolf Ranch. So this is a really important east-west connection. The red line you see, and that is probably a little bit closer to completion, is the Mark Shuffle coming from the south, connecting through Sterling Ranch and the Schmidt property, which was just recently approved by the board, over to Research Parkway in the city. So that will also provide an important connection to the east. And then the blue line is the Banning Lewis Ranch North. As you see there, it's now called Percheron. That has been annexed into the city, and it is 800 plus acres that is proposed for urban level development. And the road that's coming through there, Banning Lewis Parkway, will connect between Woodman Road and Briargate Parkway, but obviously a lot further south. It will go down eventually all the way to Powers. And so that is an important east-west, north-south connector. But the result of all this is that it will take immense pressure off Woodman Road. Woodman Road can be at times congested, and this will take a significant amount of pressure off of Woodman Road. And then you are probably also aware of the widening project of Black Forest Road that is taking place right now. There are some diversions. It's obviously not a particularly friendly area to drive around at the moment during construction, but those improvements together with the connections of these roads will really significantly improve traffic in the area. And in addition to that, Volmer Road, which is effectively a rural road right now, is planned to be a 4-lane arterial. And it is being designed right now for that and will be expanded shortly. So the traffic report looked at all the surrounding traffic. In the context, we have also just updated the master transportation study for Sterling Ranch in the context of the sketch plan amendment we did in 2022. So it's all up to date, new information, and that's just been built upon with this traffic study. So as I noted, our primary access to the property will be off the Briargate Parkway extension. There will also be 2 access points onto Volmer Road. Initially, we did not have any lot access onto POCO because it was all internally facing, but we do have the individual lot access with the 2.5 acre lots onto POCO. There will be very little traffic increase as a result of those 5 lots. Then as I noted, the traffic study recommends that there will be no significant impact to the surrounding roadway system, but subject to improvements. So these improvements will be triggered on a phased basis, including the signalisation of Briargate and Volmer, signalisation of Briargate and our internal collector, and widening of Volmer, as I noted, to a 4-lane urban arterial, and also construction of the various turn lanes at the intersections on Volmer Road. So there are further road improvements that are proposed to accommodate the traffic. Natural resources, there have been a few comments about natural resources on the site, particularly regarding a ridge that goes through the property approximately in a east-west direction on the northern portion of the site. So we had our consultants, core consultants, evaluate this. They evaluated it initially, but we asked them to go back and take another look based on the comments received. Their conclusion was it didn't provide a significant natural feature. And the only things that they really pointed to were some existing ponderosa pines on the ridge that may have raptor nestings, and they since concluded that they would that those raptor nests are actually no longer being used, that they are old raptor nests, and one of them actually has fallen out of the tree. And that there are no significant urban features in the ponded areas, other than we noted that there were some trees on the Volmer Road side that do have active raptor nests, so we have preserved those in our open space. In addition to our consultants, because we are often criticised by producing reports that the county asks for, which we have to pay for, and but they're by our consultants. The county send our reports out to external agencies. So these are all the external agency comments. U.S. Fish and Wildlife had no concerns. Colorado State Forest Service had no concerns. It's a low wildfire hazard area. Colorado Parks and Wildlife indicated negligible impacts to wildlife. U.S. Army Corps of Engineers, they reviewed all the pondered areas in our property to see if they were waters of the US and concluded that they were not and do not require any permitting or mitigation from the Army Corps of Engineers. And then finally, CGS, who are the Colorado Geologic Survey, they reviewed the soils and geology report, and they concluded that there would be no constraints as a result of this proposed development. Or no constraints that would prevent the proposed development, no geological constraints. So it's been thoroughly reviewed by all the agencies, and nobody expressed any concern about natural features. Review criteria, we've gone through a lot of these already, and Ms. Parsons touched on most of them. This is really just a reminder. I'm happy to answer specific questions about the review criteria or any other comments. But with that, I'm happy to answer any questions.
Are there any commissioner questions for the applicant? Commissioner Williams.
On the water resource report, I know you said that the lots in the north were going to be on wells. What is the density lots planning to be hooked into?
What is the, sorry?
On the water, future water provider, what is the water going to be provided by on the more denser lots?
So on the majority of the site, so the 2.5 acre lots will be on well and septic, and the majority of the site, it's going to be the Falcon Area Water and Wastewater Authority.
Okay, thank you.
Any other questions for the applicant?
Thank you.
Thank you.
There are no further comments from staff, but I will put the approval criteria back up on the screen. Are there any questions for staff from the commissioners?
Commissioner Gonzalez.
Thank you, Madam Chair. So we talked about traffic, or it was brought up. So when is the expected completion for the expansion, east-west expansion for Briargate and the widening of Vollmer?
Jeff Rice again with engineering. I don't know that there's a date for Stapleton Briargate, but there is a PPRTA project and a corridor study that has been being conducted by the county. So those are kind of laying the groundwork and preliminary aspects for that. So depending on when the PPRTA project would be prioritized, like the applicant's representative said, there's different segments that would need to be constructed. So they'd look at when they would construct those for Stapleton Briargate. For Vollmer, Sterling Ranch is actually doing some segments on Vollmer where they have right-of-way and can widen it and provide access to Sterling Ranch. It's kind of a similar situation where there's one area where they don't have right-of-way yet, so they're going to do what they can, and then we have to keep looking to see if the generated traffic requires additional improvements. And when we get to those points, then that's when we're going to have the questions on how do we get the full 4 lanes. Up from Poco down, it's going to transition from 2 lanes to 4 lanes at Briargate Parkway on Vollmer. And then it'll pretty much be 4 lanes from Briargate all the way down into the city existing segments that are there.
But that's not existing, that aspect isn't existing yet?
No, like I said, there's a portion that's just south of Sterling Ranch that's not developing. So that's going to be a question of how do they get the right of way, either the developer or the county or the city to widen that part. It's actually the roadways in the city in that segment. And then in the part next to the industrial development between the north and south parts of Sterling Ranch, there's not enough right of way there yet. So those are the 2 segments that could take a little while.
Okay, and just for my concerns there are, as development gets built, clearly the upgrades to the roads in the development occur, but that's assuming they don't go anywhere. But clearly they're going to go to the city, they're going to go into the county. So what happens when you get overdeveloped in an area and those connecting roads into the city or south aren't yet done? They're still on existing narrow roads that are non-upgraded roads. And I'd like to know when we expect that to happen, because if you get full development at the developments and then we don't have road improvements on the connections for a decade, well, then there's going to be some issues on those roads.
Right. So as the development progresses with each preliminary plan and final plat, if a need is identified, then we start looking at scheduling when those improvements need to be needed or when they're going to be warranted for capacity. So we're not at the point where it's over capacity, but based on all the development happening, when we get to those, then we're going to have to address those segments between the city and county and developer on how do we complete those segments that need the capacity.
It does seem to me, so in the Pikes Peak RTA 2, it seems to me just last week, and maybe even on our agenda today, I'd have to go back and look at this morning's consent items. We've moved a whopping $16,000 from the Highway 105 project down to the Briargate Traffic Corridor Study, which is a Pikes Peak RTA 2 project.
Correct.
I fully expect that by the time we get to this project after 2025, that most of Briargate Parkway will have already been constructed by Norwood and Classic and any of the other developers along the section there.
Especially from Volmer to Meridian Road, the parts to the west between Black Forest and Volmer, that'll probably be the critical pieces to finish.
Yeah.
And then remind me, please, I think towards the beginning of the presentation, this project is paying road impact fees?
Correct. And if they build principal arterials and roads that are in the road impact fee program, there's reimbursement available for those if the developer builds those.
Great, thank you. Any other questions for staff? Okay. Are my colleagues good with pressing on before we open the public hearing part, or do you need a break now? Okay. With that, we will now take public input, and we'll start with those in support of this application. Are there any people in the audience or online in support of this application that would like to speak? Okay. Hearing none. Any in opposition? If you would like to make your way forward, you can introduce yourself and you'll have 3 minutes. Thank you.
Thank you so much, Board. My name is Pam Rokes, and our family lives directly west of this sketch plan. My husband spoke at both of the Planning Commission meetings expressing our concerns. After the last Planning Commission meeting, I went home and thought through what were my objections. And several things came to mind. And first, I just want to say I take exception to Mr. Bailey's comments to us at the end of the meeting when he said residents are trying to move the goalpost of what will satisfy them, and that while it's difficult to adjust to change, especially when one has lived in a place for decades, development in high priority areas is inevitable. When we first moved to Poco Road 24 years ago, we were thankful to be in an area that was zoned RR5. We were close to the city, yet out where we could have horses, chickens, very quiet, and we had something to pass on to our 2 girls. Little did we know until the first Planning Commission meeting that we attended that we were suddenly considered suburban. We had no clue. We were told our properties were undeveloped, yet each home on Poco had 1 house on their 5-acre property. The main term we heard at that meeting was this sketch plan conforms to the El Paso County Master Plan. How did we miss the fact that our area had been totally changed by the master plan? Was it because it was done during COVID when there were more important things on our mind? Was it because I was taking care of my 90-year-old dad who lived next door? Why didn't we receive some kind of notification that we had suddenly gone from RR5 to be a suburban area? The fact is, the master plan is in place. We're not trying to move the goalpost. We just want the transition that the master plan mentions. In section 14 and goal LU3, it states that undeveloped portions of the county are to be adjacent to a built-out area should be developed to match the character of that adjacent development. Mr. Bailey mentioned that it depends on which way you're looking. Well, I really feel like it should be looking from the ones that were developed first, not to the east, which has just been developed in the last 3 years. He also said the development shouldn't be a surprise to anybody. Well, it actually is, because the Jane section was in a trust. We knew that it would be developed one day. That wasn't a surprise. What we didn't know is that it could suddenly be a PUD. We did not realize that it could go from 5 acres, and we actually have 10, down to the density that they're going to do. We lived here long enough. We were in the Black Forest fire. We know what it's like and how our road was the turnaround point for people to get out of the forest. We have not had in all those years any way to escape, in a sense, if anything major happened. As Lauren mentioned, in the Planning Commission meetings, there were some residents who had not been communicated. We were not communicated. I really felt like they did a really good job with the next door, but we were never told that it was going to go down to these half acres. And we were really hoping for at least an acre. Other than that, we just want you to know we're not against development. That's not the issue. I think that what we are against is not being informed and to suddenly have this decision made for us. But I just really appreciate you listening to my concerns, and thank you. Appreciate it.
Thank you for being here. Are there any others wishing to speak in opposition to this application? Sir, if you can make your way down. And then actually, if we want to go ahead and queue up on this side as well, it looks like there's another comment from this side. And be ready to present your comments when this gentleman is done. Yes, Ms. Parsons.
Oh, I'm just helping Gary.
Okay.
Hello, Commissioners. I'm Gary Byerly. Chair, may I have an additional 3 minutes to speak on behalf of my mother, who is present?
Yes.
Thank you. Thank you.
Thank you.
Just hold the left
Yeah, you
button.
can just hold just like a regular computer mouse, okay?
Where do I go up?
Just put your hand on the mouse.
Well, he's getting that settled. What this gentleman just asked was whether time could be donated, so to speak, to a single speaker. In these agendized items, yes, we will do that, but I need to see the hands of those of you who are donating that time, just to verify. Thank you. You can proceed. Please introduce yourself.
Thank you. I'm Gary Byerly. My presentation is for posterity to show options still available, decisions made, and results of those decisions. Our 12-acre home site adjoins at the northeast corner. We've lived here 45 years. Originally 3 neighbors, the glider port, and open fields. This vicinity map is from 20 years ago. No Sterling Ranch, no Timber Ridge. Highland Park was proposing 2.5-acre lots. John had done his 5-acre subdivision. Glider Loop had established 5-acre parcels. We were certain nothing less than 5-acre sites would surround us. This is Vollmer Road. This is Poco Road. Everything north is rural, 5-acre parcels or larger. October 6 last year, Classic hosted a community meeting at Grace Church. I spoke vehemently for rural lots from Poco to the hillside ridge. Keep urban density on the other side of the ridge. Everyone from the Poco group supported 5-acre lots at a minimum along Poco. Classic heard us loud and clear. They proposed 1-acre lots. That failed at the first Planning Commission hearing. They revised that to 2.5-acre lots. Now, Classic reneges on their responsibility to provide access within their development to those lots. That places additional burden for their development on adjoining neighbors. If that's the case, you'd expect 5-acre lots next to Poco that we originally demanded. The ridge of the hillside runs from the south end of the Smith parcel to the dog leg of Vollmer. This is the hillside from the far south end. You can't see north of the ridge. From Dines Boulevard in Vollmer, you can't see north of the ridge. From future Briargate in Vollmer, you can't see north of the ridge. This is the hillside from our yard, rolling hills leading up to the ridge. The elevation of our house is about the same as the top of the ridge. This proposal intends to minimize or even wipe out the ridge, creating a general single slope from Poco to the south. It's a critical natural feature. Code 841G states the primary importance of the preservation and enhancement of the natural landscape and vegetation shall be considered. Unique or distinctive topographic features, aesthetic features, alteration of features shall be kept to a minimum. How better can I show This hillside is an undeniable natural feature that serves a critical function, protecting our properties from the noise, light, and commotion of the future highway. Code 842B2 addresses minimizing the impacts of noise to residents. Code 721DC states developments are supposed to be compatible with existing land uses. This 170-foot wide strip separating 12-acre home sites from urban density is not compatible or acceptable. Is it 170 foot? It scales and calculates about that, but the top of the page shows a dimension of 114 foot. If that's the case, it's 100% beyond not acceptable. This is not an adequate transition. Classic held private meetings with landowners on the west end to find compromise. We were not given a private meeting. We're one of the largest adjoining landowners and get the shortest end of the stick. At the west end between the Smiths and Rokes, they compromised and gave 544 feet of depth from Poco Road. Our east line with Timber Ridge has 1,000 feet of depth for 2.5-acre lots. Lots along Vollmer, from Poco to Wildflower, have a 100-foot setback. How does it seem reasonable that 4 years ago, we achieved that transition, the same builder now relegating us to a 170-foot wide strip on our adjoining front yard as a transition to urban density? Put this Timber Ridge layout on the north face of the hillside. A rural, local road on the north side of the hillside would access all the lots they're developing as it's supposed to be. We've been given this natural defining transition line between rural and urban. This ridge and north face cries out to remain rural for the integrity, distinction, and aesthetics of this area and our rural neighborhood. At a minimum, the 170-foot strip along our south line must be addressed. Put in one more 2.5-acre lot to achieve approximately 250 feet in depth from Poco for more appropriate, traditional-sized 2.5-acre lots along Poco. The developer stated at the first Planning Commission that it will be about a decade before Briargate Parkway services this parcel. There's no need to approve a sketch plan that needs considerable revisions to accommodate a more workable transition, especially for people who have lived here for almost half a century and for the area itself. Thank you for your time and consideration. I'll gladly answer any questions.
Thank you, sir.
Thank you.
Are there any others wishing to speak in opposition? Please introduce yourself.
Hi, my name is Rashawn Smith, and my husband Wayne and I live on the 5-acre insert, the Smith parcel that NES talked about. We're here to state our opposition to the sketch plan, and we feel our situation is unique and that we are affected directly on all 3 sides of our property by this. We were disappointed to learn that what we assumed would be 5-acre lots around us was being rezoned to allow urban density. You did see that the first and the second sketch plans did make changes, and we have had many meetings with Lauren of Classic Homes, but we still feel it's not compatible with the existing properties. NES showed you the densities of the properties in the area, but what is happening in the ranch or Wolf Ranch does not directly affect our property, our road, our neighbors, our fence lines. Seems like there's a lack of transition from the property behind us to the higher density neighborhoods that are planned behind us. Our 5 acres goes down to 3/4 of an acre, which is not an adequate transition. Our neighbors, Mike and Pam, have almost 10 acres, and on the south part of their property, there's only 0.7 acre lots planned next to them. It just seems like there are inconsistencies within the sketch plan regarding the transitions. Classic built the community across Vollmer, Timber Ridge, that Gary just talked about, where the 2.5-acre lots line Vollmer and then go to larger than I'm not sure the exact transition, but it does not go directly into the higher transition behind that. They taper down in that community. This is the kind of transition that we are asking for because our house, again, goes from the 5 acres to 3/4 acre. We moved out of town to get away from the crime, the density of the city. We assumed we would eventually have neighbors. We're not opposed to building in our neighborhood. We love living there. We understand why other people would want to as well. It's just gut-wrenching to know we're about to lose the pronghorn herd that travels through our yard and the quiet rural feel of our road. I even emailed media mogul Ted Turner asking him to purchase the Janes parcel to run his buffalo on in a Hail Mary attempt to keep this proposition or this plan from going forward. We ask that you vote against this current sketch plan to have Classic Homes redo their plan, again, like Gary was saying, with more adequate transitions within their community. We understand that we are just one family, but we are directly affected by this. Thank you very much.
Thank you. Are there any others here to speak in opposition? Come on down and introduce yourself, and you may begin.
Hi, my name's Wayne Smith. I'm her husband. I also live on the 5-acre lot. Just wanted to make a real quick statement.
If you would bring that microphone closer
sorry.
to you.
Is that
Thank
better?
you.
I would like to make a quick statement of clarification. I know this may seem trivial, but I have noticed during this process that perception plays a large part. NES had made a statement of the discussions we had with Lauren of Classic, of which we had many. We appreciate the numerous meetings and the conversations, but I feel the result is being skewed. It came across as though my wife and I had made the request for 0.7 acre lots behind us, and we received that. That is not accurate. That's not an accurate statement. We have always desired the largest possible lots along all 3 of our affected sides. As an example, you can have 2 lots behind us without them being limited to the 0.75 acres. There have been changes to the sketch plan, but as indicated by our presence here and our opposition, we feel they are not in accordance with the requirements of the master plan. Thank you.
Thank you, sir. Any others wishing to speak in opposition of this? Please state your name and you may begin.
Hi, I'm Lori Yoder. I live actually across the street from the Smiths on Poco Road. And we all realize that Classic is going to develop this land. We know it. Where we have our biggest issues is the wiping out of the bluff and the transitions between the 5-acre homes and all this mass development. There's got to be a better transition. The west side is going from 5-acre lots and a few 2.5 acre lots to a 0.7 acre lots with an 85-foot setback. And then behind the Smith's place, they removed the setback, they removed the buffer, and they gave them 0.75. And it's just unacceptable. Thank you.
Thank you. Any others wishing to speak on this item in opposition? Any online? Okay. Would the applicant like to address the concerns?
Yes, I would. And if you give me a second, I'd just like to refer to some of the slides on my presentation. I'm going to go right to the end, first of all, to address Ms. Rook's comments. I'll start in more general terms in terms of the master plan. The comment was made that they're just wanting the transitions required in the master plan, and the master plan does refer to transitions. There's also reference to it should be meeting the character of the areas, the built-out areas. Now, I think there's a lot of interpretation in that of what you consider to be a built-out area. As was referenced, the area north of Poco Road is a rural residential area. I would not classify as a planner of that being built out. The built-out area is clearly the area to the east, which is Sterling Ranch. So we are matching the character of that. So I think that's a misinterpretation of the reading of the master plan, in that the built-out areas that are being referenced in terms of matching character are those that have actually been recently developed, rather than the rural areas which have not. And again, I would consider 2.5 acre lots next to 5 acre lots a transition. 5 acre next to 5 acre is not a transition, it's the same. Transition suggests something different and something that gradually goes towards the more dense areas within the center of the site. Sorry, I still haven't got to the slide I wanted to get to. So there were the more general comments. Regarding the specifics, they express concern, and I might, I'm not sure this is the best one. I'm going to go to the last slide. About the relationship of their particular property on the northwest corner to the development that is being proposed. And it is my last slide that I want to show. So are you able to see the cursor on here? So this is their 10, well, they have about 8 acres. They have a couple of two plus acre parcels here and another parcel down here. But this is their home, and these are the 2.5 acre properties. So we have extended the 2.5 acre property to the south of where their residence is. Obviously, their parcel comes down to this point, and there is no development in that area. And we are that's where this is the area they were expressing concern about, where we have the 0.7 acre lots and the setback adjacent to this part of property. So I would say that we have respected the location of their home in terms of extending the 2.5 acre lots to the south past their home. Now moving on, and here I'm going to go backwards to Mr. Brierley's comments. I'm not going to talk further about the ridge. I addressed that in terms of all the agency reviews we've had that indicated that there are no significant natural features on this property. But I do want to talk a little bit about the relationship of what we're proposing to Mr. Brierley's home. I think this one will do. So this is Mr. Brierley's property. It goes all the way to Volmer. Volmer's a little bit off this slide. It goes diagonally off to the side here, but this is his property, and this is his residence. And this is the existing Jane's property. We will obviously be creating a 2.5 acre lot, replacing that existing property with a new home in this location. And this is his boundary. So alongside Mr. Brierley's property, there will be no change. There will be one home. There is one home now. There will be one home in the future, plus the edge of an additional lot. The home will be placed over here. Compare that to what Mr. Brierley indicated was a good transition, he felt, on the east side with Retreat at Timbridge, where he had 3 2.5 acre lots concurrent with his boundary on the east side. So what we're proposing here is actually better. The depth of the lots may not be as extensive as they are they're long and narrow on the Retreat at Timbridge, but instead of having 3 properties to look at, he will still have one single home on that boundary with POCO. Regarding the Smiths' comments, I will talk just generally about, again, the transition. There was an assumption there that this would be 5 acre lots. Obviously, that's not what the master plan is anticipating for this area. So it is anticipating a much higher suburban residential density. We believe that we do have an appropriate transition, again, the 2.5 acre lots. There was reference to the Retreat going from 2.5 acre lots to something more transitional, but it goes from 2.5 acre lots to 12,000 square foot lots, which are 1/4 acre. So it's not like it goes from 2.5 to 1 to half or something like that. It goes from 2.5 acre lots to 1/4 acre lots. So there was also reference about the change in the quiet rural road on POCO. We are adding a total of 5 new homes to POCO. They will be rural residential lots. It won't significantly increase traffic to the point where we won't have to do any improvements to that road. That's why previously we indicated we wouldn't access onto POCO with the larger development because it would require POCO to be brought up to urban standards. So with these rural residential lots accessing POCO, there won't be any change to the rural character of the road. And they were really all the rebuttal comments I had, but I do know Mr. Morland from Classic would like to respond to some of the comments that were made about the discussions that were had with the neighbors.
Mr. Moreland.
Good afternoon, Madam Chair and Commissioners. Lauren Moreland with Classic Homes. I'm a vice president there. So I've been handling this project since the inception. So I handled the meeting on October 6th out at Grace Community Church. We had about 36 people show up to learn about the project. Had pretty detailed conversations in regards to likes and dislikes. Obviously, a lot of those, when you hear about a new project, there's more dislikes than likes when it comes to this. And so we walked through, and we did hear. Gary walked through in detail in regards to his opinion of a natural feature there that should be preserved in that ridge. We went through extensive studies to verify whether that was. We had it studied the raptor nesting sites that were included. The various other nesting sites were magpie, raven nesting locations, many of which were down. As we worked through that, we were in a 15-month process with the Army Corps of Engineers, and ultimately ended up with a non-jurisdictional determination of waters of the U.S. So none of that was found to be required to have a permit for development and construction. So we worked through all those details. What becomes typically evident when you hold those neighborhood meetings that have adjoining neighborhoods and/or properties, you typically have a person or persons that are a little more vocal. They're the nucleus of the, I'll call it the opposition. And so in that particular meeting, the Highland Park HOA president was in attendance, expressed some of the concerns with the transition to the west, along with Mr. Rick Christian, who lives along POCO Road, stated that he'd had numerous meetings with all of the residents along POCO, and that, so there were a couple of the folks that I found that were disseminating information back to their neighbors. And it's easier to work constructively in those smaller groups, in my opinion. So what I elected to do was about a month after our initial neighborhood meeting, I set up another meeting with the Smiths, with Mr. Christian and the HOA president and secretary from Highlands Park to discuss comments that we heard and adjustments that maybe appealing to them or work with them. Sorry, lacking the word. But so as we work through that, we added the buffer, similar to what Andrea showed in Sterling Ranch and the ranch from years past. 50-foot buffer, half-acre lots. And then adjacent to POCO, we had initially a buffer with 1-acre lots. We removed the buffer. Nobody was a big fan of the buffer along POCO, incorporated that into the lots. And then at Planning Commission, again, most of the homes to the west were just being built, so there was not a lot of resident interaction there. And so that's why we had the HOA board members. And so as we worked through that, ultimately at that last meeting we had with them, they were very happy with adding the buffer, adding the additional setback, and frankly, their comment at the tail end of the meeting was, wow, we didn't think you guys were going to work with us at all. So when we showed up to Planning Commission in February, and there was the 5-3 vote against, we were a little surprised by a few of the comments. And one was the area to the west didn't want that buffer based on foot traffic and based on trash and et cetera. So one of the Planning Commission members mentioned that we should incorporate that buffer into the lot and increase the lot size, which we did. I also learned during a short recess during Planning Commission that information wasn't being disseminated out to all the neighbors on POCO. And so a few of the residents grabbed me to voice their concerns. That's when Mr. Stimple came before you and requested that we continue and go back to Planning Commission. So we made those adjustments. We are accessing onto POCO with those 5 additional homes. We did incorporate the buffer. And then the Smiths I wanted to touch on last because I've had numerous meetings at their home with them. I know, as Andrea stated, that based on comments from Planning Commission, that extending the edges to the east and west was part of the conversation. The Smiths have always been clear about getting as large a lot to the south of them as possible and or lots. As I worked with them, it was laying out, there was a buffer, and then there was half-acre lots, and then we separated that down to ranch restricting those smaller lots, still even with the corner. Based on the last Planning Commission meeting, we again expanded those areas. That's why we showed the slides in regards to the grade differential there in relation to elevation. So we've worked closely. I don't know that we'd, without going to very large lots, would find 100% resolved there, but we feel like through the conversations and ranch restrictions, I think we've been very transparent with one another that this was as close to common ground as we could hope for. I don't know if that's worded correctly, but, and then I wanted to touch on a couple things outside of the resident meetings. Commissioner Gonzalez, we have posted assurances for the work to be done along Vollmer. We have numerous plans in the system for Mark Shuffle extension that will ultimately connect. Right now, the first segment is already built, was recently paved in Sterling Ranch. There's a small section connecting to the south. Those plans are currently in review, and we hope to commence construction this summer. The Vollmer South improvements is what we call that, from kind of the south boundary line of Sterling Ranch up to the industrial site. Those plans are approved. We should have all permitting approved. We were hoping by end of day today, and we hope to commence construction in the next 30 days on the widening of Vollmer. Frankly, we were holding off on the widening of Vollmer on that stretch because, as many of you might be aware, the intersection of Vollmer and Black Forest has been closed for a stretch, and there's been a lot of traffic congestion out there. But we're kind of at a point, if we're going to hit this paving season, we'd like to start those sooner than later. We have plans for what we're calling Vollmer North along that Briargate stretch up to Poco in process now. We have Briargate Parkway from Vollmer eastbound to Wheatland in process, under construction. The next segment will take a bridge crossing across Briargate. We have those plans approved. We have permitting through the Army Corps of Engineers. So we're making great strides when it comes to the connectivity out there of these various major infrastructure roadways. So just wanted to touch on a few of those items. Any questions for me?
Commissioner Gonzalez.
Thank you. So, regardless of whether they're considered significant land descriptions, the ridge, are you guys gonna shave the ridge down?
Those detailed grading assessments, we did a small one that we're showing here along that far north boundary. And ultimately, we've got a layout that comes more at the next stage, the preliminary plan stage, where we're laying in utilities, where our utility connections are. That's going to drive a lot of that. But I would tell you, yes, there will be grading along that site. Can I tell you the level of that grading today? No, not until we get further into the CDs, the construction drawings.
So potentially get rid of the entire...
Balance it. So an area that would not be considered that's lower may end up being filled. So you might create more of a balance across there of that ridge. Will there be shaving of that ridge? Generally, as you look at a lot layout and the roadway going through there is going to be cuts and fills and balancing of the dirt.
All right. And then there was some slides with like the neighboring developments for comparison purposes. Could somebody scroll through a couple of those? I just kind of I just want to take a quick look on some of these.
Let's see.
Yeah, no, those, yeah, if you can go, those are the ones. Nope, there you going.
Did you want to go back one?
Yeah, you passed the two that I wanted to
Go
look
back,
at.
Sorry. This one here?
No, the ones with the dwelling units. There you go. Okay.
Okay.
So. Yeah, okay, can you go to the next one? Nope, no, the other way.
Sorry.
Okay, thank you.
Thank you, Mr. Moreland.
Thank you.
Any other questions for the applicant? I have one quick one. I think it was said, but just wanted to make sure I understood correctly, that the 2.5 acre lots along Poco Road, are those going to be served by septic? Okay. So they'll have to go through the health department septic permitting process as well?
Correct. So the intent, just so it's on record, the 2.5 acre lots will be served by one septic and they will have to go through the health department for approval.
Okay, thank you. Okay, any other questions for the applicant? Okay, the public hearing part of this is closed, and I will bring it up here for discussion.
All right, thank you. I guess I'll start off. Nobody wanted to jump in there. I do appreciate that there was a better work on the transitions, which is what I've always highlighted. I was surprised after I heard it went back and they came back with the same number of housing density, however, and why I asked about these two properties here, because again, they were used as reference as to why it's appropriate on the this property going forward as being compatible. Well, there's a little difference because Vollmer is actually almost kind of a natural buffer, and you have the east part of Vollmer where you have a higher density, and then west where I would consider, let's try to transition that to the 5 acres. And in one of the slides, it shows 5 to 12 dwelling units per acre on the property that's being brought forward today. And then, as I've seen often, compared to other units, but in those, the highest I see are 5 to 8 dwelling units. So you're actually going higher density than the ones that are previously approved that are being used as comparison purposes. And again, I have no idea what a landmark is, but on the slides from the gentleman, it was pretty clear the only real landmark in that area is the ridge. And that's what stands out to me. I still have concerns about the traffic, but I appreciate the fact that the starting looks like that might be not as big a concern. But again, I did think it was going to come back as slightly less dense. And when I see it in certain areas, higher density than what it's being compared to as asking us to approve it, it concerns me. So thank you.
Commissioner Williams?
Yeah, I do think that this is an area of change in our county master plan, and I didn't know if while I was talking, staff could bring up the approved criteria. Thank you. I am actually impressed by the level of effort of Mr. Moreland and Classic Homes to work with those individuals on Poco Road, as well as the lots to the west. It's because I know it is a growing area and it is hard. So I just wanted to state that I appreciate the efforts between Classic Homes and also the individuals who live along this area. Thank you.
Resident Commissioner. Okay. Commissioner Geithner.
Thank you, Madam Chair. I think that one of the difficult parts of land use hearings is taking a look at that criteria and hearing the various levels of subjectivity on things like our master plan. And, you know, today and at other hearings, I've watched very sincere people make comments to say that it absolutely is in conformance and it's absolutely not in conformance. And that's one of the reasons why, you know, having this public input is an important part of the process, because it really allows us to hear those arguments and realize, you know, and create for us individually the opportunity to assess those arguments and come up with which ones we think are the strongest. So in this case, I do also have to say that I am incredibly grateful to the applicant for taking this back through the Planning Commission. I think that was a good choice because seeing those Planning Commission votes is very helpful. these are folks who obviously look at the master plan, look at all of these applications on a regular basis. And so, seeing them ask for very specific things to be changed, having those things changed, and then going back through the Planning Commission to see an approval, an overwhelming approval in this case, does speak volumes to me personally when we're trying to hash out what those conformance things are, and specifically the wide interpretations in that situation. It helps me to look at those who are truly looking at that criteria objectively, where they're at on this. So I think, as I've often said in these hearings, I grew up in a rural area, and I watched areas directly around my family's property change very drastically. In one case where we had a trail literally up against the back fence and houses on the other side, I wouldn't speculate here on the density, but I can tell you much more dense than even the quarter acre that is looked at in this area. So I'm not unsympathetic to the concerns around this, but in this case, though it is not perfect for all the family members, it most certainly, there has been a considerable effort, it seems, to minimize those impacts to the greatest extent. And here our job is to balance the rights of everybody. And it's important to also balance the rights of the property owner. There's probably a lot of places that if we don't have any financial stake in it, if we don't have any reason, any negative downturn to us to just say, yeah, it would be great if it stayed this way. But there's no impact to us personally when it's not our property. And so that has to continually be a thing that we evaluate in this situation. So for all of those reasons and the criteria that is set out here, it does feel that or I do feel that it very clearly meets this criteria. And so for that reason, I would love to go ahead and make the motion to approve this item with any conditions and notations.
I will second that.
That has been moved and seconded. Any other comments?
Thank you,
Commissioner Gonzalez.
Madam Vice. Just because it was stated once out there and then up here, it's an average of a quarter acre. The 12 density units per acre would be a 0.08 for the smallest developments. Thank you.
Okay, that has, Commissioner Vanderwerf.
Yes, thank you, Madam Chair. And again, I appreciate this process. And I appreciate the citizens being involved in this because you spoke, and you spoke a lot. You've spoken to the Planning Commission, you've spoken here. And I appreciate the developer trying to work with the community to make some of those accommodations. And I think what's kind of interesting about this particular case is the 2 visits to the Planning Commission and kind of where the sentiments were from the Planning Commission on the first round and the second rounds. Now, not everybody is getting what they're looking for. Many of the citizens still have concerns about this, but keep in mind that because you spoke up, you were able to come to an accommodation of some measure with the developer, and I think that really speaks volumes to really good, solid attempts between the citizens that live there and the developer trying to work something out. That's really fantastic in my view. So again, while we're not quite, for many of you, you're not there as far as everything that you were looking for, I appreciate these attempts at a compromise. And therefore, I'll just make the statement that I will be supporting this vote.
My colleagues have said it well. I'd also like to take the opportunity to thank the Planning Commission as well for being open-minded and reevaluating this. We all have tough jobs of this balance that you've heard us talk over and over again about today. and we take these decisions seriously. We have clear criteria in front of us, and I'm thankful for our members of the Planning Commission, our volunteers who do this. So I'm grateful for them on that. Okay, this has been moved and seconded. Any final comments? Commissioner Williams.
Aye.
Commissioner Vanderwerf.
Aye.
Commissioner Gonzalez.
Nay.
Commissioner Geithner.
Aye.
And the chair votes aye. That passes 4-1 with Commissioner Gonzalez in opposition. And with that, we will be in recess for 5 minutes. Okay, I will call this land use meeting of the Board of County Commissioners back to order, and we are on item number 8.
Item number 8 is the map amendment rezone, 1825 Summit Drive. A request by Stephen and Jennifer Leibowitz for approval of a map amendment rezoning 5.23 acres from RR5 residential rural to RR 2.5 residential rural. The applicant intends to subdivide the existing parcel into 2 approximately 2.5 acre lots to allow for construction of a new single-family residence on the property in addition to the existing residence located at 1825 Summit Drive. The property is located at the northwest corner of the intersection at Old Northgate Road and Silverton Road. Application had opposition at Planning Commission and was denied 7-2. Denial based on perceived incompatibility with surrounding properties. Parcel number 62040-01018, Commissioner District 1, Lakeisha Bellamy, Planner 1, Planning and Community Development.
Good afternoon, Commissioners. My name is Lakeisha Bellamy, and I work for El Paso County Planning and Community Development. Today, the project is 1825 Summit Drive rezone. The project number is P23001. The reviewers for this project were myself and Carlos Hernandez, the engineer. If you're watching remotely and have not provided a name and a reliable phone number, please email that information to pcdhearings@elpasoco.com. The Planning and Community Development Department notified 20 adjoining property owners on 2/24/2023 for public hearing. Total responses were 154, 2 in favor. The applicant's request to rezone Lot 14 of Overlook Estates from RR5 to RR 2.5. The rezoning would allow the owners to apply for a minor plat to subdivide the existing 5.23 acre lot into 2 2.5 acre lots to accommodate the construction of a single-family residence on the newly created lot, in addition to the current home located at 1825 Summit Drive. Here is the rezoning criteria according to section 5.3.5. Just let me know when you want me to proceed to the next slide after you reviewed it.
Next slide.
Here's the Planning Commission summary. They voted 7-2 to recommend denial of the proposed map amendment rezone of 1825 Summit Drive from RR5 to RR 2.5. Some of the members' discussion during the board were spot zoning. RR5 zoning district is under attack. RR 2.5 is not compatible with RR5 and the surrounding area. Community concerns will establish a subdividing precedent, traffic congestion, decreased home values, and damage to well water supply. Here's an aerial map. And right here is 1825 Summit Drive. To the south is Flying Horse Ranch and Discovery Canyon School. Over here is zone RR 2.5. And the remaining properties that are outlined in brown are less than 5 acre lots, or are less than 5 acres. No, the ones that are outlined in in brown, are less than 5 acres. But they are zoned. Their zone is 5, but they're less than 5 acres.
If we could minimize comments from the audience, you'll certainly have your time to tell us what you think. Thank you.
The large lot residential place type supports the rural character of the county while providing unique and desirable neighborhoods. Relevant goals and objectives are as follows. Objective 3.1, development should be consistent with the allowable land use set forth in the place types first and second to their built form guidelines. Objective 2.6, continue to carefully analyze each development proposal for their location, compatibility with the natural environment, and cohesiveness with the existing character. In this large lot residential area, the acreage is 4.42 acres or greater. And then to the south is Flying Horse Development and Discovery Canyon Campus School. The large lot residential place type consists almost entirely of residential development between place types. Development in this place type typically consists of single-family homes occupying lots of 2.5 acres or more and are generally large and dispersed throughout the area so as to preserve a rural aesthetic. The primary land use for this place type is single-family detached residential, typically 2.5 acre lots or larger. The parcel is adjacent to Summit Drive and Silverton Road. Both are county-maintained roadways. Traffic is expected to increase by 10 average daily trips for a total of 50 daily trips. Traffic impact study is not required for the properties with a projected threshold under 100 average daily trips. Future parcel will be required to obtain a driveway access permit and pay road impact fees. The drainage report will be required at the subdivision stage. The terrain slopes down in the southwest direction, located in the Monument Branch drainage basin. Fees will be assessed and due at the final plat recording. Are there any questions of the staff? The applicant will come up.
Good afternoon, Commissioners. Craig Dossie with Vertex Consulting Services, representing not only the owners, but the residents, Jenny and Stephen Leibowitz, who are the applicants on this proposal. So what you're being asked today is to consider a rezoning for a single lot. That lot is lot 14 of the Overlook Estates subdivision. Currently, the lot is zoned R5, which is a minimum 5 acre zoning district. Again, we're proposing R2.5, which would require a minimum of 2.5 acres to plat the property, basically to add one lot is what we're talking about. Not two lots, just one lot. The practical effect, again, is really pretty minimal. We're just adding one more lot. I'm going to show you how minimal that actually is in application. Just to orient you on where we're talking about, the property is located just north of Northgate Road. I think Lakeisha did a good job maybe orienting you in the near proximity to Flying Horse Ranch, Discovery Canyon. You also have the City of Color Springs here, some higher density, obviously City of Color Springs here, higher density. All this is county. You have Highway 83 over here. You're going to hear from a lot of residents in this bigger area. These are not residents necessarily that are immediately adjacent, some of which exceed the area shown in this map, just for context. So I want to highlight a couple things in the review criteria. Lakeisha laid those out very nicely for you, but I do want to highlight a couple words that are of critical importance when you consider a rezoning. First off, review criteria number 1 says general conformance with the El Paso County Master Plan or substantial change in the character of the neighborhood. It's not an and, it's an or, which means you can find either one. The second criteria, I'm going to go through that. There is really no concerns there. Some of that's enabling legislation for the purposes of planning and zoning. But the third criteria includes another or, and that one is whether the proposed land use or zone district is compatible. So I want you to keep that in mind as I go through my presentation. I'm going to apologize now. It is a little long. I'm going to try to go through it quickly, but I think given the number of comments that came out when notice went out and the number of comments at Planning Commission, it's probably worth it to go through this a little bit slower. So I'm gonna walk through the review criteria. I know that's important. That's what you base your decision on. That's what your resolution, hopefully of approval, will touch on. So with regard to review criteria number one, we're going to look at the county master plan. Lakeisha walked through a little bit of that, but I want to walk through a little bit more of the context of how that plan got put in place. That plan was not done overnight. That was a 2.5-year process that was done during COVID, even after COVID, even before COVID. There were a lot of opportunities for the public to engage in that process. There was over 3,800 residents and stakeholders that participated in that. 3,800, that's a lot. To get anybody to participate in something that the county's doing is difficult, unless it's a hearing like this. But when we're talking about master planning, it's tough. There were a number of community workshops that were held in the north end of the county. I put down one here at Bear Creek. There was also, I believe, a series of meetings at the Black Forest Club up in Black Forest as well, which is where staff had those meetings with residents, talk about the future and how we're going to manage growth as a whole, not as individual areas, but as the county as a whole. It's important to note that master plan was adopted by the Planning Commission, and then it was certified by you, the Board of County Commissioners, in 2021. The idea for that plan was that it would be a comprehensive plan for all of El Paso County, not for one neighborhood, not even for one small area, but for all of El Paso County. And what that meant was it replaced all the small area plans. I'm going to touch on the Tri-Lakes Comprehensive Plan just to give you a little bit of historical reference, but all those small area plans have been replaced. There is one document in El Paso County that's intended to guide development, and it's your El Paso Master Plan. So also important to understand that the plan's intent, and this is a quote taken directly from the plan, is to identify key areas of focus, define a vision for future growth and development, and provide guidance for county actions and investments for the next 20 years. County, not small area, county as a whole. The other overarching intents behind the plan were we needed to pull back, right? The county wanted to pull back because there was so much weight being given to the small area plans that certain areas were able to preclude development from occurring in their area because of the plans they had in place. And what that meant was that growth then got pushed somewhere else. And growth in this community is something that the community has to deal with as a whole, not on a neighborhood by neighborhood basis or on a small area plan by small area plan basis. Essentially, it identified that the tail had been wagging the dog, and that the dog should be wagging the tail, and that being in the form of a new master plan. The master plan, and I'm quoting here directly from the master plan, was developed to create one comprehensive strategy for the county moving forward. One. It's looking at growth as a whole throughout the entire county. And what that translates to is that the fleeting desires in some of these small areas should not outweigh the plans, goals, and objectives of the larger county. Lakeisha, I'm not sure if she touched on the area change. This property is included within the area change of minimal change developed. That means that there is development in this area, but it also leaves room for additional change to occur. I can't think of anything more minimal than splitting 5 acres into 2.5s. That's about as minimal as you can get and affect change on this property. And I took this directly from the master plan. The minimal change developed areas are likely to see more intense infill development. You may not think of this as an infill development, but it is. All right, we're chopping off part of a property and we're going to put another house on there, a house, one house. It also says that the new development pattern and differing intensity in their overall character should be maintained. I'm going to identify for you exactly how that character is being maintained. Lakeisha touched on the place type. Excuse me. That place type is large lot residential. I highlighted some key terms in here. This large lot residential area consists almost entirely of residential development. That's what we're proposing. We're not proposing anything else other than residential. Typically consists of single family homes occupying 2.5 acres or more. That's also what we're proposing. It generally supports accessory dwelling units. I'm going to show you a map that shows how many accessory dwelling units are in this area. That plan supports all those accessory dwelling units that all the neighbors have, but it also supports exactly what my client is proposing. It also recommends that this area has more of a sense of community, but is more connected. More connected means it's closer to the city of Colorado Springs, more connected to urbanized areas. It's not out in a more rural area. It also identifies that they typically rely on well and septic. That's exactly what we're proposing. All of these highlighted terms 100% support what my client is proposing. Probably the most telling of all of these quotes and most relevant to this application is the very last one. I'm going to show you some topography on this property and in this area that suggests that we are exhibiting a unique character of the area because of the geography and the topography and the landscape in this area. It is very unique, and that's part of what we're going to show you. Some additional goals and objectives from the master plan. The Housing and Communities chapter, which is chapter 4 of the master plan, says that we should be focusing on focus detached housing development in the large lot residential area. That's the area that we're in. And that is primarily due to the increasing infrastructure and environmental constraints. Chapter 4 also suggests that we should support the development of housing types that further support aging in place. Now, on its face, this may not seem like that. But the idea for my clients is they would like to stay in their existing home, but they don't want to maintain 5 acres anymore. It's a lot. 5 acres is a lot. I don't want to maintain 5 acres. I'm sure they don't. It's a lot. They want to split it in half so that they can stay in their home and maintain 2.5 acres. So that was all review criteria. I'll call it 1A. 1B is whether or not there's substantial change to the character in the neighborhood. And the last 6 words here are the operative words, since the land was last zoned. The last time this property was zoned was in 1955. You don't have to live in this area to know that there's been substantial change to the character of this area, most notably the Flying Horse development. In 1960, as I mentioned before, the Overlook Estate subdivision was platted that added 14 lots. I have to imagine that at that time, pretty much everything was 35 acres or bigger. So that was a lot of change, even at that time. Then in the early 2000s, all the way up until I believe still today, the Flying Horse development started developing in the city of Colorado Springs. And that is all of 1/10 of a mile from this property. I'm not talking about miles of separation. We're talking about 1/10 of a mile. And that the closest part of that came in and started developing in 2005. And I'll show you those aerials. In 2004, and I think Lakeisha highlighted this property, there's property to the west that is similarly situated to this property in proximity to the city of Colorado Springs and Flying Horse. That property was approved for rezoning to R 2.5. Not only was it was approved unanimously by the Planning Commission and by the Board of County Commissioners. And then over the course of time, and there are obviously various dates, there have been 30 either accessory dwelling units or that rezoning I mentioned pop up in this neighborhood. 30. If that's not change, and the series of events that have occurred since 1955 are not change, I don't know what is. So just to orient you on the property within the subdivision, this is the subdivision map. My client's property lies off of Summit Drive. Again, this is Old Northgate. City of Colorado Springs is right here. Taking the subdivision boundary as our neighborhood and looking at a bigger area, you can see the size of lots in the city of Colorado Springs. These are somewhere in the neighborhood of one-third acre, sometimes even a little bit smaller in some cases. So I'm going to walk you through the aerial. I think the aerial is pretty impressive. In 1999, here's the property. Nothing, right? Nothing. City of Colorado Springs doesn't exist in this area. You have, 2.5 or 5 acres, excuse me. But you're already seeing growth in this area, in the Glen Eagle area. There's interest in developing in this area. 2003, the first area of Flying Horse pops up, north of Northgate Road, right? That's an operative condition here. North of Northgate Road. We're talking about how we're transitioning from the city into the county. So this is 2003. 2005, a lot more is starting to pop up, starting to encroach into this area of the county. Right or wrong, that's what happened. We're looking at areas less than a mile. This one's 1.7, 0.8, 0.1. You have residents that are opposed to this that are greater than a mile away. But you have city residents that are well within that on much smaller lots. 2011, you have full encroachment all the way up to Northgate. with the development Flying Horse Ranch. All of this is less than 3/4 of a mile. So again, our proximity to the city of Colorado Springs is 1/10 of a mile. That's 530 feet. So I want to introduce a concept to you here about how you transition from urban level development to rural development. This is taken from the American Society of Landscape Architects, identifies the urban core, that'd be the city of Colorado Springs, goes out to what I'd consider attached single family, maybe multifamily housing. You go to very dense single family housing. Then you start working into your suburban areas and then your rural zones. Keep this in mind as we move through this presentation. First off, the property was zoned RR 2.5, again, immediately adjacent to Northgate, similarly situated to our property. It was approved unanimously. It was reviewed under the old master plan. So the new master plan is not bringing this idea of 2.5 acre zoning to this area. It was already there with the Tri-Lakes plan. And it was already there in the approval made by the Planning Commission and the Board of County Commissioners. That project was called Tuscany Estates, and I want to highlight a few excerpts from that, taken from the staff report. They highlight that the recommended future zoning be at least 2.5 acres. Right, this is 15 years ago. This isn't today. This isn't a new concept. Staff even identified that the present development patterns include 2.5 and 5 acre densities, and that they should continue. That's exactly what we're proposing today. But going back to the previous slide, what I want to highlight for you is this concept of a transition between the city and the more rural areas of the county. Staff in that staff report said transition areas occur at the boundary of the planning area and or at the point where when land with differing uses or densities meet. It is often desirable to have a gradual change rather than an abrupt change in land uses and density. Stepping it down from 1/3 acre lots in the city of Colorado Springs to 2.5 acre lots on the north side of Northgate makes total sense. That is a transition. It's a transition to the greater 5 acre and maybe bigger further north. Some other citations from that staff report. The basis for the recommendation, they recommended approval, staff did. The basis for this recommendation is the clear inference that lots as small as 2.5 acres should be allowed in this sub-area. So that's not even the whole Tri-Lakes plan. That's dialing it down all the way to the Ponderosa Breaks sub-area. Staff goes on to say there are few other areas in this sub-area that would be better candidates for 2.5 acre lots. And this is due to the proximity of the parcels immediately north of Old Northgate Road in relation to the planning and the development that was going to happen in the city of Colorado Springs. They knew it then, and we're seeing it now. Staff also said, and it's important to note, that this will create a reasonable expectation of additional conversion to RR2 in the vicinity. That's now called RR 2.5, requires 2.5 minimum acreage. They're looking in their crystal ball and told everybody this is going to happen. And it's a logical progression in this area as a transition between the city and the rural areas of the county. So I want to identify a little bit of hidden change that's occurred in this area. And maybe the residents behind me don't even know this. The hidden change is in the character of this area. And it's popping up in the form of accessory dwelling units. Because it doesn't require subdivision, because it doesn't require rezoning, there's no public hearings, right? But it's happening. Every one of the properties that we've identified in orange here has an accessory dwelling unit. And there's 12 of them located within 1/3 of a mile of the city boundary. Here's an example of that hidden change. I would argue this isn't that hidden because it's pretty impressive in terms of the amount of buildings. This is basically across the street. 2 full-size structures. This one's actually very large. 2 full-size structures on this property, single property. Visually, this looks no different than if you subdivided the property and did 1 house on 2.5. It's exactly the same. There's another example. It's buried back in the trees. I can tell you, I drove by this. I took these pictures. These houses are big. They're bigger than my house. There's 2 of them on the same property. That's hidden, right? Because they're not before you ask for a rezoning. But it's there. That density is there, and it's increasing every day with the approval of these. You got 2 more coming online. 1 already here, 1 being built. Same property, 2 structures. Nobody can see a line here, right? If you subdivided this, you're not going to see that lot line. It's an imaginary line, but it looks exactly the same. So what I would submit to you, commissioners, is there is already a density transition that has been forming. If you look at each of the orange properties that have those dwelling units, accessory dwelling units, look at this next to the city boundary, plus your R2.5 rezoning. It's already happening. The fear that change is coming with this application today, their timing was 20 years ago. Their timing was when all these ADUs were approved and were constructed, because that's the change. And the residents may not even be aware of this, but the same thing's happening further north around these smaller lots. You're developing another transition area. So for me, it wasn't enough to just show you which ones had approval. I thought it was more important to show you the structures. 2 structures, 2 structures, 2 structures. This one's attached with a breezeway, I believe. 2 structures, 2. This one's in a basement, so you could argue this one's actually a duplex. This one's attached. Here's your R2.5 zoning. That would allow for 2 structures and 2 structures. Here's my client's property. In order to subdivide it and have frontage, they have to divide it this way. This has more spacing than this property or this property or this property. You could argue even this one. How is that any different than what's already been constructed and approved in this neighborhood? It's not. So going back to what I presented before about the density transition, you can see, and I flipped this image, transitioning from south in the city of Colorado Springs to north in the more rural areas of the county. It's already happening. This lines up perfectly with what's happening in this transect with what's reality on the north side of Northgate Road. So one of the things I highlighted earlier was the topography in this area. And I think this transition area is developing the way it is for a reason. And that reason is there's a substantial ridgeline north of the subject property. The gain from the south end of my client's property to the ridgeline is 83 feet. 83. You can't see any of these homes from the other side of this ridge. And then on the back side of that, it drops 82 feet. The top of this is almost 7,200 feet. That is significant. You talk about screening, you talk about transition areas. God made a transition here by putting this ridge here. That's why you're seeing all this stuff pop up on the north side of Northgate, because it's not the same as the stuff on the north side. We agree with that. You're going to hear from a lot of the residents that they're fearful that this is going to progress further north. I don't think it will, and I think this ridge has a lot to say about that. So this is Nina's attempt at a cross section of that hill. I think it looks pretty good, actually, better than I can do. But it shows you this is to scale. This is 15-foot home, single-family home. That's the Leawood's existing one-story house. There is no way anybody from the north can see this structure, and definitely not the new one, because the new one's actually even a lower spot on the property, going to the west. So again, topography is creating this density transition in this neighborhood. Like it or not, that's what's happened. So this gives you, and of course, photos never give a good idea of topography and elevation. This is my best attempt at taking a picture. This is looking from Plier Drive, which is just over the hill, kind of at the bottom of the hill, looking north. Leawood's house is nowhere to be seen. And of course it's not going to be. We're talking about 83 feet of rise. So this is looking, you're going to hear a lot of opposition from this area. There's nothing for them to see. One of the most concentrated areas of opposition to this rezoning was in the Craig Drive and Silverton Road area. All these properties were opposed to this. I want to highlight for you that this intersection is 3/4 of a mile north of my client's property. 3/4 of a mile. So what does that mean? And this is actually an image from that intersection. So again, no visibility. What does 3/4 of a mile mean? Well, I think to be fair, we need to look at where 3/4 of a mile is going south as well. 3/4 of a mile encompasses most of the golf course at Flying Horse and a large portion of the residential. So if our friends up on Craig Drive are part of the neighborhood of the property that we're representing, then so should the City of Colorado Springs residents. And if that's the case, then the density transition makes even more sense. You can see there, I did measure exactly 3/4 of a mile. So this was actually really hard to get because of the visibility with all the vegetation, but this is an image taken kind of looking northeast from Northgate Road towards my client's property. This is the very top of their house. You can barely see it, hidden behind the oak brush and other trees. The proposed new house would go basically right in the middle of the oak brush in a very low-lying area. So again, all the opposition is up over this hill, over, well, in some cases, over a mile. So bringing those two maps together, showing where the ridge line is, showing where all the accessory dwellings are, you can see where I'm getting this idea that topography is creating this density transition area, which is fortuitous. Otherwise, it may continue. But when you go out there, they are two different areas, two different neighborhoods. Everybody here deals with the impact associated with Discovery Canyon. We all love schools, but we don't all like the traffic associated with schools. And I promise you, they all are dealing with it. My client said they line Northgate trying to get into the events hosted at the athletic fields. They don't have the same issue north of the ridge, right? They're not parked in front of their houses, in front of their lots. I apologize. I'm only through one criteria, but I promise they're going to go quicker. Review criteria 2 references several selections from state statute. I'm going to tell you that there are no concerns, and you never hear concerns on those because they kind of are what they are. The first one is enabling legislation for the county to do planning and zoning. The second one allows you to zone based on size and use. And the third one we are in compliance with. The legal notice was prepared and published, but it does also require the full membership of the board vote in favor of this in order for us to get approval today. Criteria 3, again, this has that or, right? The proposed land use or zone district is compatible with existing and permitted land uses in zone districts in all areas. Let's talk about land use compatibility. Currently, the property is zoned R5. The list of uses I put here are all uses you can do in R5 that you cannot do in RR2.5. What that means is my client is willfully giving up part of that bucket of uses that comes with the RR5 zoning. And I will highlight that some of these I think would not be compatible with the neighborhood. Agritainment, we've seen some of those that have extensive traffic generation. A dairy, duplexes, golf course, that'd be a high water user. Greenhouses, halfway house, I think we can all agree that's probably not compatible with this neighborhood. Major kennels, these are full-blown large-scale kennels. Mobile homes, wholesale nursery, recreation camp, temporary housing, and tree farm. If the concern is about water, then everybody in the neighborhood should be running into your office to rezone to RR2.5, because all of these uses, like with maybe a few exceptions, would be significantly higher water consumers than splitting a lot from 5 acres to 2.5. So my client is willfully giving up this bucket of uses. What are they gaining in exchange? How many uses are they gaining? Absolutely none. You don't gain anything. R2.5 exactly mirrors R5 except that you get these additional uses with the RR5. You don't gain anything. So in terms of compatible land use, 100% compatible. I would argue that some of the other ones maybe aren't as compatible with what's existing unless they rezone to RR 2.5. So that's the first half of the OR. The second half of the OR is whether or not the proposed zone district is compatible. Taken directly from the Land Development Code, both share the same title, residential rural. That's because both can be done on well and septic. Section 3.2.2 of the Land Development Code identifies the purposes of both zone districts. They are exactly the same. The only difference is 5 acres or 2.5 acres. 100% compatible. So the last review criteria is suitability of the site for the intended use. Obviously, a water sufficiency finding is not required, as you know, at the zoning stage. It will be with subdivision. Having said that, my client's already gone through the process with the state to get their decree to make sure that they have enough water. Rather than doing a spec rezoning and then finding out later you don't have the water, they found out they do have the water. And they went through the process, actually, of getting decrees for all 4 aquifers. All 4. Most people don't do that. Most people focus on the Dawson because that's the shallowest. But it may not be the most responsible approach to it. Their existing exempt well for their existing house was approved in 1989. It limited the use to ordinary household use, gardens and lawns, watering domestic animals, livestock. And then the new adjudicated rights, which again was done in 2022, for all the aquifers, Dawson, Arapahoe, Laramie, Fox Hills, I guess not Denver, but I think they already had Denver, included domestic use, irrigation, stock watering, fire protection, that's a big one, given the history of that area, and storage and augmentation. They've already made the investment to make sure that they had the water. You're going to hear a lot of fears about the wells and my well's going to go dry. And you all know this because you commissioned the county's water master plan. You've seen this detail before. Where the property sits is one of the most saturated areas of the Denver Basin. Not in the county, anywhere, including going north into Douglas County. If you look at the cross section, this is taken directly from the county's water master plan. I estimate the property is located about here. That is the thickest, one of the thickest areas of the Dawson Formation, one of the thickest of the Denver Formation. And this is why they got their water rights decreed for all 4 aquifers, because they sit on all 4. That's a responsible thing to do. So the groundwater fears, they're not there, right? We all know that groundwater is it's a very precious commodity, but it is also a property right. And my client owns those property rights, just like they own the surface estate, and they have a right to use that water, just like everybody else does. Some of the other things that go into site suitability, whether or not there's a floodplain, the nearest floodplain's over a mile away. A lot of the other things, as you know, will come about when we get into subdivision. Looking at making sure there's on-site wastewater treatment locations. There has to be 2 per lot. We'll have to go through that process. Doing a soils report that gets reviewed by a Colorado Geologic Survey. That's going to happen. Drainage report, and then ultimately well permitting. They've already gotten they'll have to go out and get commitment letters from these providers, but all those providers have already said it's fine. We have no issue. Don Westcott, no comments. Mountain View Electric responded, no objection. Black Hills did not respond, but they're already serving the property. I will highlight also for you that staff report does not identify any site suitability issues. So with that, commissioners, I'd be happy to answer any questions on behalf of my client.
Do we have any questions for the applicant? Commissioner Williams.
Yes, so when you were talking about the map where it showed all the accessory dwelling units, this actually might be a question better for staff, but we just discussed this earlier today. Most of these accessory dwelling units you're saying weren't approved, they've just been built?
All the ones in orange were approved. All of this information came out of EDARB. So there may be other ones out there, right? But there's no way to know for us to research that because they're not on file. So all of these have gone through the county's process. They're legitimate, but they're there.
Okay, thank you.
Any other questions for the applicant? Okay, thank you.
Thank you.
Is there any more to the staff presentation? Okay. Okay, thank you. With that, we will move to the public input part of this hearing, and we will first take any input or evidence in support of this application. Is there anyone present in support of this application? Excellent, thank you. Come on down, state your name, and you'll have 3 minutes, sir.
Great. Hello, can you hear me? My name is Greg Wolf. I've lived in the immediate area, approximately 5 lots away, for over 32 years. I support the project. I believe in personal property rights. I have as the past manager of a title insurance company for 30 some odd years. I protected private property rights, and I support it 110%. Thank you.
Thank you, sir. Is there anyone else in support of this application? Anyone online? Okay. We will move to anyone in opposition of this application. Can I see a show of hands? And we'll make this as easy as possible for everyone. Excellent. Do we have anyone online waiting in opposition? Okay. So at this point, we will have you kind of self-queue up a little bit if you can on using both aisles so we can be efficient. Each person will have the ability to have 3 minutes. I understand, are there a few who have requested to donate their time to a single person? Okay. And where's the single gentleman who was going to speak on their behalf? Okay. Sir, if you would, we will start with you and have each of you who are donating your time to this gentleman in the purple shirt, just raise your hand and we'll total the clock, Nancy, to 3 times how many hands we see, which is, somebody help me.
Madam Chair, can I clarify? There actually are
There are several.
7 or 8 of us who are going to present in sequence.
Okay.
But I believe each of us would get 3 minutes. Folks would help us.
Okay. All right. As long as, here's what I would, say that again.
If each of us runs over, can you ask for a hand to donate time to that particular speaker?
You know, I think we have an audience full of people who are passionate and all on the same side of things. So what I would ask is that you be efficient and not repetitive. Pay attention to what others are saying. That's what I hear you have come forward with a coordinated deal with that. Let me get a quick show of hands of what if you're donating your time to anyone. Okay. Thank you. Keep them up if you would, please. Thank you. Okay. Okay, we're gonna go with, and you said all, and you have 7 or 8 of you who are actually doing the presentation on their behalf. So let's go with 17. No, 17 citizens. So set the whole timer and you guys go through and have efficient transitions based on the slides you were going to present. Try not to be repetitive and we'll go from there. Okay, with that, and each speaker, please introduce yourself. Thank you.
Good afternoon. Thank you for putting up with this shenanigans on the timing. My name is Jerry McLaughlin. I live in Sun Hills. As you know, we're going to do a tag team approach, and if I could get some help to pull up our presentation, I sure would appreciate that. Okay, as we said, that we're going to have a little tag team approach here. And again, I appreciate your indulgence on that. We're going to hit spot zoning, rezoning criteria, compatibility, property rights, community sentiment, and summarize a position. Before I hand the podium over to start the circus here, I want to just comment on a few things. If you'd please consider the area that's under consideration, and there's been a lot of maps put up here. You'll note that the large area of yellow is contiguous areas of RR5 parcels that were zoned decades ago at 5-acre lots. And to quote the zoning criteria, there hasn't been a material change in the character of those lots or this area since originally zoned. There have been some second homes in place within the few 5-acre lots, as was pointed out. These are not zoning changes. These were accomplished via special use permits. That pattern is well established and compatible with the current zoning for the area. Again, not acreage splits. As Planning Commissioner Fuller stressed at the Planning Commission meeting, placing a second home on an existing lot is completely different than what's being requested here. They're requesting to split the lot and sell the lot, a split. A map earlier presented indicated there are several less than 5-acre lots in this general area. That's correct. But looking at the El Paso County Assessor's Office, they're nearly 5 acres. An example is 4.78, 4.85, 4.79, etc. I believe most of these are all as a result of acreage variances and administrative relief using the 20% variance margin that the county has granted. A perfect example of this is the three nearly 5-acre plots shown on the east side by Roller Coaster. I believe these were because Mr. Wolf, who was just a previous speaker, eventually splitting all of his 13.66 acre plot into 3 almost 5-acre lots. After being denied twice in 2013 when he attempted a similar request to split those into 2.5 acre lots, he ended up getting the variance into 3 almost 5-acre lots. The objections made then are still valid. The applicant has not offered any examples of changes in the neighborhood which would warrant such a zone change. The applicant's comment about the Overlook Estates as being a separate HOA community is technically correct, but frankly, we're all in this together. We're all part of the same 5-acre contiguous lots. In fact, if you were flying over, you would see the only differentiation between Overlook Estates and Sun Hills is a 3-wire or a split rail fence. That's it. And those fences are there to keep our horses in place. One more quick comment. As you saw, there's 150 plus letters of opposition to this, and there's 2 letters for it. One of the letters happens to be from a realtor who just spoke, who only stands to gain in this type of environment. Now I will turn the podium over, and again, I thank you so much for your time. I know it's been a long day for you guys.
Hello, Commissioners. Thank you for your time. I appreciate you staying so late. My name is David Todd. I'm from Raton Road on the Sun Hills Estates area. I represent my family when opposed. We are opposed to the requested variance by the applicant. I'd like to read briefly from a publication by the University of Denver Law School's Colorado Land Planning and Development Law 9th edition, which is a publication of the Colorado chapter of the American Planning Association. I had lots of other notes, but so many people have said this. So, the master plan of a county or region shall be an advisory document to guide land development decisions. However, the plan or any part thereof may be made binding by inclusion in the county's or region's adopted subdivision, zoning, platting, planned unit development, or other similar land development regulations after satisfying notice, due process, and hearing requirements for legislative or quasi-judicial processes as appropriate. I would just like to say that in addition to this, in a quote, even if a master plan is considered only an advisory document, zoning that does not conform with the plan may be subject to an attack as spot zoning. Spot zoning is prohibited in Colorado on the theory that a local government cannot act merely to benefit a single landowner, but must act to the benefit of the general public. Does this request relieve a certain piece of property from zoning restrictions in spite of, rather than the conformance with the jurisdiction's comprehensive plan? When in evaluating a rezoning application, a local government usually asks whether the proposal complies with the comprehensive plan. If so, the proposed rezoning need only bear a reasonable relationship to the general welfare of the community. If the rezoning would be in conflict with the comprehensive plan, however, the applicant generally needs to show either that an error was made in establishing the current zoning, or there has been a change in the conditions of the neighborhood that supports the requested zoning change. We believe that there have been neither been a past error nor a material change in the character of the neighborhood that requires a rezoning benefit to the public interest. We believe this request is spot zoning and only benefits one single homeowner applicant. We are relying on the existing zoning regulations as they have clearly laid out the criteria for rezoning, and we do not believe this application meets that criteria. Finally, I'd like to remind the commissioners that the prior Planning Commission meeting, Planning Commissioner Fuller stated, and I'm paraphrasing, that she sees this request as spot zoning, and she does not think this rezone is compatible to the area around it. Neither do we. Thank you for your time.
Okay. Hello, Commissioners. My name is Joe Squattrito. I live on Raton Road, not too far, just to the north of the subject property. We've heard a lot about zoning criteria, and I want to give you a different perspective on this. We've reviewed the 4 criteria provided to us by the Planning Commission staff, and we believe that none of the criteria have been met to justify rezoning. So one criteria involves any possible error or oversight in the original zoning of the property. Well, there's no error here, so that's an easy one to contest. In fact, the Board of County Commissioners Oversight and County Plans have long held this as RR5 property, so there is no error there. Yet another criteria involves a condition involving any material change in the character of the area. The property is north of Colorado Springs city limits and lies within the rural El Paso County, so there's been no material change. Once you step into that county zone, it's always been RR5, and we believe it should remain unchanged. Another of the criteria surrounds the idea that the requested rezoning would be in conformance with or consistent with the county's master plan. Our view is that the county master plan is quite clear in consistently holding that this rural part of the county is zoned RR5. So the uniformity of the RR5 properties across this rural area underpins the county tax assessment of these properties, and we believe there is continued need for consistency in maintaining RR5. Finally, the county's criteria involves whether the requested change is necessary for the general health, safety, or welfare of the community. So, as been pointed out, this change would only benefit the current landowner and would not provide any improvement or benefit for the rural El Paso community. Our assertion, any assertion by the applicant about providing benefit to the community is simply unfounded and without merit. So in summary, thank you for your time. The county's established criteria, in our view, has not been satisfied, and the view was validated in the recent Planning Commission meeting with a vote of 7-2, and as not being compatible with the existing rural area. So we would urge the Board of County Commissioners to deny this zoning request. Thank you.
Hi, my name's Julie Haverluck, and I'm going to be speaking on the issue of the incompatibility of RR5 and RR 2.5, because it won't be just one lot that will be opening, but will be opening the door for requests to subdivide other lots. In the interest of time, I'm not going to reread this code, but continue to the next slide. In the planning language, the designation large lot residential includes RR 35 down to RR 0.5. As you can see from this slide, there is a dramatic difference in the density of development between these categories, which are neither equivalent nor compatible. Planners are well aware of these material character differences, or they would not have created separate designations for them. RR 35 and R5 maintain a more rural character, while R 2.5, so this is RR5, RR 2.5, is more accurately described as light suburban and 0.5 as dense suburban. In addition, there's a big distinction between the maximum coverage allowed in these two types of zoning. The maximum allowed coverage on an RR5 lot is 25%, while there is no coverage restriction on an R25 lot. And accessory dwellings are not the same thing. The 100+ letters of objection from neighbors indicate that the majority of citizens agree that RR 2.5 zoning is not equivalent nor compatible with RR5. RR landowners have chosen to live in this area because RR5 allows neighbors to live independently in a rural setting. By choice, neighbors hardly hear or see each other during daily activities, and we're privileged to protect and provide wild habitat for wildlife. In contrast, landowners in R 2.5 choose a more suburban lifestyle, with neighbors in much closer proximity. They have twice the density of homes, which means half the distance between them. It means a much more significant level of impact on the vegetation and wildlife, transforming the area into suburbia. It means that there's twice as many properties generating noise and significantly more light from indoor and outdoor lighting and car headlights. It means twice the number of wells being tapped into a rapidly depleting aquifer, and twice the number of septic systems and leach fields, creating a higher risk of contamination. It means a significant increase in traffic congestion and noise on the nearby roads, and twice the number of homes for firefighters to protect or evacuate in this fire-prone area, with many more chances of fires being started, resulting in much higher property losses and higher risk of injuries and deaths. Again, because it's not just one, it's opening the Pandora's box. The rezoning request directly conflicts with the stated goals and criteria set forth by the El Paso Land Development Code, core principles and goals. The development plan states that zoning protects the rights of the property owners while promoting the general welfare of the community. Goal number 1.1 is to ensure compatibility with established character and infrastructure capacity. And goal 2.2 is to preserve the character of the rural and environmentally sensitive areas. The rezoning request of the individual property at 1825 Summit Drive to RR5 or 2.5 is not compatible with current rural RR5 zoning that has existed since 1955 and would not fit with the zoning of the lots contiguous to it in all directions. RR5 zoning is the appropriate established development pattern in this area, and it's part of that civil contract into which the landowners knowingly entered when they purchased the property. Rezoning this property would lead to other properties being allowed to rezone individually, and this would irreversibly change the rural character of the area and lead directly to the degradation of the health, safety, and welfare of the existing community, in direct violation of the stated purpose of the county's master plan. I therefore urge the board to vote against rezoning.
Thank you. Property rights is not a criteria, but it got brought up at the Planning Commission meeting in the rebuttal to the community statements. You just heard Greg Wolf come down and just say he's for property rights. I want to assure you that all of us who are objecting to this are for property rights. But property rights aren't hand-wavy stuff. you all, through staff in the county and the like, have defined property rights, as has our Colorado State Constitution. And the most immediate definition of that at greater specificity is our El Paso County Land Development Code. And that code gives us a definition of just what that is. So if the code says you can do it, that's your property right. If the code says you cannot do it, it is not your property right. So to be clear, right now, the applicant does not have a property right to do what they're asking for. They're asking you to change their property right. They're not asking you to defend their property right. In contrast, those of us who are objecting have a property right we are asking you to defend. So this is common sense. This came out of a legal document that's been cited several times in Colorado, but it says that when the general zoning ordinance is passed, those who buy property in zone districts have the right to rely upon the rule of law that the classification made in the ordinance will not be changed unless the change will be required for the public good. It says required. It doesn't say because somebody would like it to be done. Okay? So those of us who are here objecting, we have bought property in this zoned district, and the law says we have the right to rely upon the law that it will not be changed unless it is required for public good. There has been no argument that this is for public good. Sure, there have been some suggestions that transition might be better. That's a silly argument. When Flying Horse went in, the transition was done on the south side of what's now Old Northgate Road. There are buffers. There was grading to lower the level of the houses. The transition was there. It's a silly argument to say that changing one property using a spot zoning kind of approach in the middle of this large contiguous area of RR5 has anything to do with transition. So that's what we have to say about property rights. We're here to ask you to defend our property rights. So then there was another thing about water, and I'll just speak to that for a second, because there was the assertion in the documents submitted by the applicant that they were in keeping with the El Paso County Water Master Plan. And in that plan, it says that a goal is to ensure an adequate water supply in terms of quality and so forth. Well, there's nothing that they did by having some lawyer file to assure that they own the water under their property. That didn't add one drop of water. There's a fixed amount of water there. There's so many straws pulling out of that cup of water that no legal document is going to add water down there. So while they're suggesting that since they're going to measure how fast the water is being depleted, that they're in conformance with the Water Master Plan, is another silly sort of suggestion. You know, we're just going to watch this auto accident happen in slow motion, and we're going to know it's happening. But contrast that to one of our neighbors in a letter pointed out that his well level is dropping 5 feet a year. The property immediately adjacent to this one, to the south, had to put in a new well because the Dawson is being depleted. So I just didn't want to let sit the notion that what they're doing is in compliance with what's intended with the Water Master Plan, because all they've done is gotten some legal mumbo jumbo done that says they own the water underneath their property. Great, you know, any of us can do that, but it didn't solve the problem. Putting another well in there is going to exacerbate the problem. So we're asking you to decline this proposal because it is harmful to our property rights and harmful to our public good. Thank you.
Good afternoon. My name is Alan Wright, and I live probably a tenth of a mile from the proposed subdivision, dividing this property. And I'm going to apologize up front. I did not sit down with everybody and review their talks, so I might cover some things redundantly, and I apologize. As of last night, there were 100 families, and now we find out there's 154 families against and 2 for. Okay, there's a map that we tried to put together last night with the addresses that were identified in their correspondence, and these are all the homes that wrote letters in opposition to this proposal. My house is, if you go right up to roller coaster, I'm the second little identifier there. We've lived there 19 years, my wife and I. Over and over, the residents cite their concerns of maintaining the character of the area and the incompatibility of subdividing into smaller lots. One letter written to the Gazette, such an action will be at the expense of every property adjacent to Old Northgate and on either side of roller coaster. It will forever alter the distinct and rural nature of this community. Probably the most frequently cited concern is precedent. Residents are alarmed that, should this effort succeed, what would prevent others from seeking and being granted the same concession? Okay. As so many citizens express, if you allow this, on what grounds will you deny future applicants? There's a passionate concern for safety and integrity of our water supply. We've talked about that. Back when Greg Wolf was petitioned to have his property divided, it was stated in the Planning Commission, in the Board of Commissioners, that the aquifer was changing not 7 feet per year. That's 70 feet it has dropped in the last 10 years. Two seasoned realtors that we spoke to concerning property value in the immediate area, okay, that all the properties within a minimum of 1 mile will approximately go down by 25%. Okay, rezoning is ultimately not in the best interests of the community, said Brian Bowles, who is a resident and realtor of the area. At least 4 military families spoke in opposition. Russ Schumer says that after more than 12 moves during his military career, he and his family could settle down and live in their forever home. He wrote, "We could have selected other neighborhoods, but waited on our dream lot." Okay. The Grosses touched on many of the themes articulated by the others. Subdividing existing 5 lots would damage the environment, strain our water supplies, add more traffic, and depress our property values. Consideration of the harmful precedent this would set and the detriment to our RR5 neighborhood should far outweigh the self-interest of a single property owner. On behalf of all of us present and the many who could not attend today in person, we are trusting you to protect the future of our community and maintain the integrity in which it was developed. I thank you very much.
Good afternoon, Commissioners. I'm Ray O'Mara, Major General, U.S. Air Force, retired. After 31 years in the Air Force, where I was required to live cheek by jowl with my neighbors on bases because of my responsibilities, my wife and I came to beautiful Colorado, where we have happily lived on 5 acres for 23 years in peace and quiet at a reasonable distance from our neighbors. We vigorously oppose this rezoning application. If it were approved, it would set a dangerous precedent which could lead to compromise our most pleasant environment and that of many of our neighbors. We very much appreciate in March the Planning Commission's comments listed in front of you. As mentioned previously, we strongly support property rights. we are asking you, as our commissioners, to protect our property rights by denying this request for rezoning. Thank you very much.
We didn't have a nice wrap up. That was our presentation. Thank you.
Thank you very much. One more.
We have a follow on,
That's fine.
but that's different. Okay.
May I proceed? Please introduce yourself.
Good afternoon, Commissioners. My name is Joshua Mangelli. I represent Mary Bruning, who lives about a half mile from the subject property. Just to be clear, Madam Chair, I was one of the individuals to which some of the time was waived. So 4 individuals had meant to cede their time to me during my presentation. I don't think I'll need all of that, but just wanted to clarify that the 51 minutes from the prior speakers, hopefully some of that can carry on. The proposed rezoning to higher density is a clear example of spot zoning that violates not only Colorado law, but this county's master plan, and also threatens to disrupt the character of this neighborhood and community. I want to focus on 2 requirements for approval under section 5.3.5 sub B of the Land Development Code. In particular, I want to focus on the fact that the rezoning is not in compliance with all statutory provisions applicable here today, and the application is not in conformance with the El Paso County Master Plan, and there has not been substantial change to support a rezoning in this case. I want to dive a little bit deeper into spot zoning because as an attorney, I believe this is served up a bit as a perfect example of what spot zoning is and precisely what should not be allowed in terms of rezoning property. The standard's been stated, but I would also point this commission's attention to Colorado Revised Statute 3123-303, which when referring to zoning amendments requires that any zoning amendment shall be made in accordance with the comprehensive plan and must promote the general welfare. In land use law, that statute is seen as prohibiting spot zoning because, of course, if it only benefits an individual property owner, it cannot also advance the general welfare of the community it surrounds. The staple case in Colorado law that addresses this is Clark versus the City of Boulder. It's a 1961 Colorado Supreme Court case in which the Colorado Supreme Court overturned approval to rezone property. The Supreme Court there stated and held that the rezone could only be justified to benefit the landowner or the applicant. And because there was no clear benefit to the general welfare of the public or neighborhood surrounding, the zoning change could not stand. The test, as has been discussed, is to establish whether the change was made to further the comprehensive plan or merely designated to relieve property from zoning restrictions. And I want to address particularly what the applicant has put forth to you today. The fact that the landowner has chosen to go through the rezone process as opposed to approaching an ADU, which is permissible under the existing zoning, suggests that what they want is spot zoning. Because the only justification, if the two are truly identical, as the applicant would like you to think, the only difference in this case is that the rezone allows them to sell the land and develop a new house separate from their current existing property. What would lead them to want to do that? Financial gain. Now, there is nothing wrong with financial gain. I'm not against it. No one here is against it. But spot zoning calls out specifically that if approval is just to allow someone to acquire financial benefit without any justification that it benefits the surrounding area, it cannot stand. Now, applicant could have approached the ADU manner, but did not, and instead is seeking to be rezoned in this case. Now, there are also Colorado Supreme Court cases that have said, we're not going to find that this is spot zoning, and I want to, in full disclosure, present those to you as well so you can see the distinction in this case. One of the cases is Information Pleas Incorporated versus the Board of County Commissioners of Morgan County. In that case, the applicant sought to rezone their property from agricultural to industrial use in order to install an electrical generating plant. There, the application was approved. The reason it was not found to be spot zoning is because the BOCC was able to articulate a clear public good that the electrical plant served, of course, providing energy to the community surrounding it. Applicant cannot articulate a similar public good that this spot zoning, one-off zoning, brings to the community surrounding it. Certainly, there would not be such overwhelming opposition to it if it truly benefited the community in which it is located. The other case is Whitelaw versus Denver City Council. This is a 2017 Colorado Court of Appeals case in which that court stated that a rezone from single family to a 3-story apartment building was justifiable and not spot zoning because adjacent properties were similarly zoned. Properties just across the street as part of the same neighborhood had the same zoning designation. And since it was not just a one-off, that should not be found as spot zoning. If this Board of County Commissioners approves the application that's been submitted, you will create an island of zoning in which no property adjacent to the subject property shares the same zoning. As much as applicant provided historical context, the neighborhoods that are more developed, more densely developed, are vastly different neighborhoods. They are significantly more dense, they're separated by major roads, and they feel incredibly different. Now, of course, applicant's response to that is, well, we're not significantly changing it. We're just going from rural residential 5 to rural residential 2.5. But if you pause and think that that is akin, or it is, increasing density by 200% on that single lot. And if you pause to think in the neighborhood in which you live, whether it be suburban, urban, residential, a 200% change in density would feel like a significant change to the character of the neighborhood. Now, I want to refute this argument that ADUs are pretty much comparable and amount to the same, but of course, that's not true because they would have gone through the ADU process. I think that's fair to admit. If it was the exact same and could accomplish the same, why not just get an ADU if it's permitted? But the reason is there's significant limitations in El Paso County law on what ADUs can be. There's height restrictions, there's setback requirements, there's family limitations, and of course, you cannot sell the underlying land. The fact that ADUs exist in the neighborhood is not justification for allowing subdivision of this property and should not be considered as such. I want to shift just briefly to the fact that this application is not in conformance with the general master plan. And this is a bit of a tricky exercise because as you see every day or in every hearing, it's very easy to cherry pick quotes that make it seem like, of course, the master plan supports your position. But unfortunately, that's just what the applicant has done, is cherry picked just what is favorable for their application. But there are 3 crucial ways in which it does not conform, the application does not conform with the master plan. First, it contradicts the stated goals of the master plan, and some of these have been mentioned, but I want to highlight a few of them. First, one of the points of the master plan is to ensure compatibility with established character and infrastructure. If applicant's argument is persuasive or wins out today, they've offered no reason to limit just wiping out this rural residential area, right? The sort of implementation over time of more dense development in the area suggests it is inevitable that this area becomes more densely developed. But that's not what the master plan states. The master plan states that the BOCC and the community need to protect rural areas in particular. Why? Because they're valuable. And while the county needs to grow, while there needs to be denser development, it should not come in an area of minimal change. In fact, the El Paso County Master Plan calls out plenty of other areas, even large lot areas, that are ripe for development. applicant also sort of skirted over the definition of infill development and stated that this is essentially what that is. And from my perspective, in practicing land use law, this is nothing like infill development. Infill development is developing property that is vacant or underutilized. This property is not vacant and it's not underutilized. In fact, it's utilized in precisely the same way all of the neighboring property is used. So to sort of skirt over that as if this is infill development supported by the plan is simply not true. One goal specifically calls out that the master plan is intended to preserve the character of rural land. And finally, I just want to call out that it is also inconsistent with the large lot residential use definition. And specifically, if you refer to page 21 of the master plan, there you'll see the following provision. Conservation design should routinely be considered for new development within the large lot residential place type to provide for a similar level of development density as existing large lot areas. What applicant simplifies or oversimplifies is this idea that because it's a large lot parcel, anything 2.5 or above is a go, should be allowed because that's what a large lot parcel is defined as. But that's not what the master plan says. The master plan says that you need to keep the zoning density similar to what already exists. And that's what binds the BOCC in terms of what the rezoning should be. The last point I'll raise, and I will be done after this, I promise, is the concept of property rights, which again, I know has been raised, but that same Supreme Court case, Clark, that I mentioned before, also mentions this. And I know Mr. Bruning brought up a case, it was a New England case, but the Colorado Supreme Court has held the very same thing, that you have a right to know what your zoning is, and that it's not going to be changed unless it benefits the public at large. And that is a requirement under Colorado law, that the right of neighboring properties, the right of all of us when we buy property to know what we're getting ourselves into, cannot just be arbitrarily disregarded to the benefit of an individual property owner. So for the reasons I've stated, the reasons I've articulated, particularly that this violates Colorado law, and second, that the application is not in conformance with the master plan, I respectfully ask that you oppose the application. Thank you.
Good afternoon. My name is John Turner. I'm a resident of Sun Hills. I'm also a 25-year realtor from that area with several agents that work for me. Done many real estate transactions in that area. I'm here to tell you that some of what these people back here said is not true. Probably 1,000 different conversations I've had regarding 5-acre purchases in that area. At least 1/3 of those conversations that I've had, the buyer, and I'm just talking about the buyer, have wanted to know, is this stuff going to be subdivided? Will I be able to subdivide it or won't I? No, you can't subdivide it. Zoned out. Not going to happen. And probably 1 in 10 would walk away at that point. My feeling is, if you allow this subdivision to take place, the next time I get a phone call on that, as an ethical realtor, I'm going to have to tell them that within a mile, the county allowed a subdivision. 9 of those buyers will walk. And what do you think that's going to do to these people's property values? And I admit it, mine too. I've lived there for 30 years. So the prescription that this is all good, well, and wonderful, and this is all about how great Colorado Springs is, and this is all, we all just need to accept the fact that we're all going to be subdivided. Everybody up there on that hill bought 5 acres and read the covenants. And that's one of the reasons they bought it. Mr. Leibowitz, maybe he bought it thinking he could shovel in a subdivision, but he can't. But I've been doing this for 35 years, and I've sold a lot of properties up there. And I'm telling you, their property values are going to drop significantly if that happens. Thanks for your time.
Madam Chair, just to be clear, I think that our group thing is done. The clock is back. That we undershot our time. Thank you.
Thank you for that. Nancy, did you hear that? We can reset the clock at 3 minutes, and I'm just going to trust that none of you who are still coming up raised your hands to donate your time. Okay.
Hi, my name is William Davis. I go by Bill. I'm taking my wife's 3 minutes in case I need it, but I've got to cut it down as much as I possibly can, just the essentials where I think I can add something to the conversation. First, I've been there for 26 years. I have the property immediately to the southeast of the Leibowitz property. We were about to go in with them on a high-speed internet about 2 years ago when our well ran dry. No fault of theirs, of course, but living on a well like that, it was getting more and more marginal as we went. But when it went dry, you're looking at $20,000 right on the spot just to get them to drill the hole. And there's no guarantee that the day after that they're not going to have to drill a new hole or go to a lower aquifer. So we got lucky. It's working okay for now. But the extreme concern for me is the water, number one. I'm not going to get into more details about that, but just to say that there's a lot of pain with that. Helped to wipe out our savings. Secondly, I want to mention the congestion. This isn't necessarily in order, but over the 26 years, our fence has been hit almost annually by people coming down Silverton Road. We get it all. Everything goes past our house. We live on the corner of Old Northgate and Silverton Road. And once they put the development south of us in, the intersection was totally messed up. It ought to be a four-way stop. But we have accidents there more than annually. I mean, 2 or 3, 4 times a year with a lot of high school kids learning to drive and other things like that. Separate issue. I'm sorry to hold you up on that, but let's see, cutting it down as quick as I can here. I don't know if you, on 5 acres, we have habitat. Not only we have squirrels and rabbits and everything else you can name and birds, but on occasion we'll have deer that give birth. So you guess you could call that habitat, but it's preservation of the area. You can do a lot better on 5 acres than you can on 2.5. And this is supposed to be horse property, up to 4 horses. Can you imagine putting 4 horses on 2.5 acres? I can't imagine even 4 horses on 5 acres, but a separate issue. Another quick point on the environment. I don't know if you just heard a day or two ago, J.P. Morgan said that all private property owners ought to give up their property to help the environment. Something to think about. And by the way, according to Klaus Schwab, by 1930, you'll own nothing but be happy. So tell me how that works. I'd like to start working on that. A couple more things I just want to ask, maybe more of a rhetorical question with the Leibowitzes. Our covenants already allow a second dwelling on the property, and I'm not sure why that wouldn't work for them, almost as well as trying to subdivide. They told us that it was to increase the property value. I don't see how it does that, but one more minute here. On the same point, I want to correct an item about the property across the street from it that has the 2 houses. The smaller house was on the property to begin with all along. Probably a 2-bedroom house, may have been there before they subdivided it. Obviously, they got a variance to put the larger house, which was a major improvement to the property, next door to it, but it wasn't. They did not subdivide it, and that's true of all those other properties. I think that point came out, but I just wanted to bring that up. And in the off chance that you should approve this thing, then I'd like to apply to subdivide so I can sell and get out of there and maximize my sale. Thank you for your time and the patience.
Thank you. Please state your name for the record, and you may begin. You'll have 3 minutes.
I have to lower this. Hi, I'm Marianne Hastings. I live just down Roller Coaster Road on Evergreen Road, and they talked about almost everything that I wanted to bring up about the water, except that you guys might not know this one thing. It's very unique. On our property, we have a mini continental divide on our property. We had to do 2 water reports in because it goes to the Platte and goes to the Arkansas. So water's always been a concern for me. My mom and dad lived here. They bought a house that was built in the 60s, and they lived here till they died. They lived about 50 years, and they had to put a new pump in their water. We're all on the Dawson, all of us up there. And they said in the 90s, the Dawson hadn't gone down 1 inch. Now you hear what's happening. And we're concerned about that. The other concern I have is the fact that there's precedents. Mr. Craig talked about the fact there's 30 other allowances and waivers that happen. Why? I mean, why, if there's a precedent, it's automatic rubber stamped yes? And he says, well, there's probably not going to be very many more. Right where we live, they've taken 1 acre lots and reduced them to 3/4 of an acre. How are they 600 feet away from each other for, sewage and water? I want you guys to look at this and look at this uniquely. I know that you said yes time and time again. I appeal to you like Mr. Gonzalez, you had that feeling. Well, because they've done it so many times before, I'm going to say yes here in Black Forest. There's a reason to feel no. This is one of those reasons. Thank you.
Thank you. Please state your name.
Right there, due to hearing.
Okay, and you'll have 6 minutes then.
Thank you. My name is Kelly Soria. I'm a resident of Colorado Springs on Roller Coaster Road, where we have just under 9 acres. After serving over 30 years abroad and now retired as a Navy veteran, my partner found our forever home in 2014 and knowingly bought it because the land was zoned not to be split, because that was a very important factor in purchasing the home. My family and I are within the impacted area and not above it, as stated by our applicant's representative in his introductory blanket statement. I am 1.3 miles within a driven area, and thanks to his circle, probably 3/4 of a mile, probably less, as depicted on his presentation. So definitely within the impacted area. As Mrs. Brenning's lawyer stated, better than I can, this request is not looking at or addressing accessory dwellings or units. The examples provided are akin to stacking the deck. I want to point out that in the presentation, there's a slide titled Hidden Change. Those examples are not confirmed of accessory dwellings. I think Commissioner Williams might have had some questions on it, but it was the next slide. For example, that slide has 1 to 10 different examples. Number 4 is a house listed as an accessory dwelling with a breezeway. That's actually a garage. They're connected. That's how the house was built. It's a newer home that was just built last year. Oops. Hold on 1 second, my thing got locked. And so if pictures were taken of our property, you might mistakenly think that we have ADUs, when in fact we don't. We have an old A-frame that holds wood and a shop, but they could look like additional units. At our residence, we are a multi-generational adult household of 5 that we all have similar concerns and objectives or objections. We're all agree that rezoning to smaller lots has lasting implications and that we're just not comfortable with it. Had we known that we too should have submitted a letter, we would have done a firm letter of opposition, but instead we came in person. We're objecting due to the setting precedents and having more possible approvals of rezoning of 5-acre lots to smaller lots. Additional housing will expand and create more traffic on Roller Coaster Road. So please bear with me for just a moment while I give you a brief description of that portion of the road. It starts with 35 miles per hour. It's aptly named Roller Coaster Road because of all the hills and dips. It is lined with Gamble Oak and Ponderosa Pine that lend to a shared living space for mule deer, turkeys, occasional bears, and other wildlife. This description is important because in the last 4 years, we have had new safety concerns from the expansions of neighboring communities and sales of empty lots and new houses being built. Specifically, with us as well as our neighbors, we are concerned with either entering and exiting our driveway. We've called the sheriff many times. We've almost been hit crossing the road to get mail. We don't need any more traffic. And if we have additional houses, that's exactly what will happen. There are 3 primary roads for egress: Highway 83, North Gate, and Baptist Road, which are already concerns if there is a fire. Imagine having any of our 9 acres, other lots split to 2.5 with additional houses. How are we getting out? Finally, I believe that the intent for most of us living in an area that is zoned as residential rural is to live in an acquired area, to experience home life in an area that has limited traffic, surrounded by wildlife, decreased light pollution, and large lots with open space. Rezoning to smaller lots takes away from that original intent and away from our forever home. Thank you for hearing me.
Thank you. Is there anyone else wishing to speak in opposition? Definitely sound like a broken record now. Just state your name for the record, please, and you'll have 3 minutes.
I'm Ben Kelly, and I think I'm being donated 3 minutes extra.
6 minutes, Nancy, please.
Is there a way to project something here?
Yes, you can just lay it face down on the projector there. Yes, sir. And then can we get the projector? There you go. Thank you.
This is a map from the assessor's office. And you'll see here, if you look at this type map, first let me say, the applicant's consultant gave a very convincing presentation, very polished. And you're probably also aware he used to be the executive planning director. So he's very skilled at this. And his presentation was very convincing. But if we had more time, I think I could pick apart a lot of it. Some of it is misrepresentation, and there are some omissions that would tend to bias your decision. Now, if you look at this map, you can drive through this area and you won't notice any changes. It's all homogeneous, mostly the same. He spoke to ADUs and this being a transition unit. Well, those things are permitted by the land code, ADUs. That's not a transition. And so Overlook Estates was platted in 1960, as he pointed out. Sun Hills was 7 subfilings between 1958 and 1962. I believe there are about 3 lots left in Sun Hills to be developed. So this is a developed area with its own character. And the areas to the north, Pleasant View Estates began platting in '64, Glen Eagle in the mid-'80s. And then we have this annexation from the south that none of us wanted, but that's what we got. And so annexation to the city sort of follows different rules, as I understand it. So I claim that there has been minimal change, no change to this area, no material change. A rezone here would be a material change. And we'll get to some statutes that talk about material change. To address the master plan, I've watched here this afternoon how these various presentations tend to pick out things of the master plan in order to support their cause. And I understand the master plan to be an advisory document, and that's supposed to guide you in your decision making. And so it's very flexible and can be interpreted in various ways by whatever your agenda might be. But it identifies this area as minimal change developed. And core principles and goals, there's theme that goes through the master plan about ensuring a compatibility with established character and preserving character and that sort of thing. And the attorney spoke to these very well. What strikes me, though, about all of these different presentations regarding the master plan is that they omit page 142 of the implementation, which states the county's land development code governs the use and development of property and provides the legal framework for implementing the master plan's recommendations. So these goals are just broad ideas to guide you, but the Land Development Code is a derivative from state law, I believe, and so that is what should be the legal framework, as the master plan says. Now, for criteria 2, I won't go over some of these because the attorney already has, but I will point out that there were some omissions in the consultant's presentation. There is CRS 3123-301 that says property owners have the right to rely on existing zoning regulations where there has been no material change in the character of the neighborhood. And 30-28-111, which he referred to, he left out part of, the landowner is not entitled to the most profitable or best use of his property. So those are parts of the statutes, and it seems to me a rezone here is not only an island rezone on the interior of this developed minimal change area. I just had a brain fart. So let's look at the criteria 3 then. The consultant addressed these, and table 5.1 and 5.2 list the uses. There are 30 differences in permitted uses. But if you look at the criteria, it doesn't matter if one use is a subset of another. It doesn't say that. It says existing and permitted land uses in all directions. Existing and permitted land uses in all directions. This is an island here. In no direction are the existing and permitted land uses the same.
If you would wrap up your comments.
Yes.
Thank you.
Now, in the 4th criteria, you know, there were things about intended use. It says, I just want to point out one thing. It says, let's see, it's suitable for the intended use, and talks to standards and dimensions and that sort of thing. Well, how is this applicable if the intended use isn't permitted? So it seems to be conditional on permission of an intended use for this to apply. But that's my interpretation as a layman. Thank you for your time, for listening to some of the rants that aren't very coherent maybe, but I believe, in my opinion, that at least 3 of these 4 criteria are not being satisfied.
Thank you, sir. Is there anyone else? Yes, sir.
Commissioners, Terry Stoker representing the Black Forest Land Use Committee as well as the Friends of Black Forest. When the new county master plan was being developed, we were concerned about unintended consequences. We knew that that was a very likely possibility. We campaigned hard for 5-acre density in the Black Forest area because we felt that was important for preservation of trees, wildlife, and for the spirit of that. I will beg to differ with Mr. Dossi that one of the purposes of the county master plan to be all combined was to prevent fleeting tastes in land development. And I would say that the Black Forest Preservation Plan was 50 years of history and 50 years of precedent. And we were assured by the planning department that the new plan would protect us because in the 5-acre lots,
we would be surrounded by 5-acre lots so that we wouldn't be divided into smaller lots. We would be protected because we had conservation design, which means that there would be open space protected and that it would be compatible with what was surrounded. If you look in the master plan, those are the 3 criteria: 2.5 acres, which we disagreed with, but that's what it went to. The second one was conservation design, and the third one was compatibility with surrounding properties. This does not meet that. And we would ask you to look at that and realize people buy 5-acre lots because they want to live on 5 acres. We do not want the powers that be to do rezoning or allow division of lots for the purpose of more housing in areas where people have bought lots that are what they want. We're in favor of accessory dwelling units because that's a temporary use for a very specific purpose. But this is not that. You've heard plenty about that, so I'm not going to go into that again. So I just ask you to look at the history, look at the conditions here, and see that this does not meet that. Thank you very much.
Thank you, sir. Is there anyone else wishing to speak in opposition who has not already spoken or donated their time to someone? Okay. Hearing none, I'm actually going to suggest we recess for just a few minutes again. And when we get back, the applicant will have a chance for rebuttal and we'll close the public hearing. We are in recess for 7 minutes. Thank you for your patience. I will call this meeting back to order. And we had just wrapped up all of the public comment in opposition. And at this point, if the applicant chooses, they have an opportunity for rebuttal.
Thank you, Commissioners. Craig Dawson with Vertex Consulting Services again. Genuinely want to thank the neighbors. As you all know, I'm a big proponent of public involvement, trying to reach the right conclusion. Certainly understand all their concerns. Obviously don't agree with a lot of them, but I would like to walk through some of the things that I heard. Some people talk really fast and I write really slow, so if I miss something, I'm sorry, but I would like to address each point that was brought up, at least the ones that I felt like were pertinent to the review criteria of the rezoning. Mr. McLaughlin, I think, was the first one that spoke from Sun Hills, obviously championing the RR5 zoning. This won't affect that at all. They can keep their RR5 zoning. As I suggested, they're over the hill. As far as I'm concerned, they're a completely different neighborhood. They function like a different neighborhood. A lot of folks brought up, don't affect our property rights. Rezoning this property doesn't change their property rights. They have the same uses under the RR5 today that they'll have tomorrow, that they'll have 10 years from now, unless they rezone their property. None of that changes. Now, they may not like that there's a potential invisible line drawn on my client's property, but nobody will be able to see that. And they'll have the same number of structures that you see on so many of the other lots in the quote-unquote neighborhood. It was convenient that one of the maps that was put up had my client's property all the way at the bottom of the screen to show all the letters of opposition. Hopefully you took from that how far away some of the people are that oppose this. And if you think any of their properties are going to be materially impacted, or their property rights associated with that property are going to be materially impacted by this decision, that's ridiculous. We're talking 1 mile, 2 miles away. You had somebody get up and speak to traffic on Roller Coaster Road. This property won't access Roller Coaster Road. Traffic from this property will never go to Roller Coaster Road unless they're going to Fox Run. It's 1/10 of a mile from Old Northgate. That's where the traffic's going to go. A lot of discussion about spot zoning, which I appreciate. I think that's an astute comment. I do disagree with it, as you would guess. I think it was really fortuitous. And his name was Todd. I didn't catch his last name. I apologize. He was on Raton Road, which is considerably north of the property. He cited an article. And I want to bring in a portion of that article that he glossed over. This is written by Don Elliott, considered to be probably the most sophisticated, well-versed land use attorney in the state of Colorado. I've been on the same panel with him on numerous occasions, speaking to things involving land use law. I'm going to summarize what he says because it's attorneyese, frankly, and it's kind of thick. Basically, what he's saying is you cannot have a spot zoning if the zoning implements the master plan. Your master plan says this area should allow for 2.5 acre lots. And that is all we're talking about today. We're talking about rezoning to allow for a 2.5 acre lot. How in the world is that spot zoning when your master plan specifically calls out an allowance for that? That's a tenuous argument at best. Mr. Artero, I think, or Miss Artero, I'm sorry, actually went through the special use criteria. That obviously is not applicable here, so I'm going to just move on beyond that one. That was not the rezone criteria that's applicable to this project. Miss Haviland, I think was her last name. I couldn't hear a lot of people. She mentioned, she put up a slide comparing the size of lots for for A35, R5, R2.5, all the way down to R0.5. That allowance in the master plan is based on one thing. It's based on conserving land through easements, through open space for large scale developments to allow for lots to go down to that size with an overall density of 2.5 acres per lot. That was completely misinterpreted. I would encourage her to read the rest of the plan because after you get through the place types, there's a very good layout of what conservation design looks like. I'm going to go ahead and put that up on the screen. We get the overhead, Nancy? The image on the right is making sure that we're keeping those natural areas natural, minimizing the footprint of development, as opposed to the image on the left, which is what you see in older developments in the county. I would say most developments now implement this conservation design principle. The attorney that spoke suggested that somehow conservation design is not being implemented with the splitting of 5 acres into 2.5s. I'm not a landscape architect, and I'm sure he's not either, but I don't know how you'd go about doing that on splitting 5 acres into 2.5s. I can tell you the 2 lots are going to be next to each other, which pretty much emulates conservation design. Again, that's a pretty tenuous argument. There was a lot of comments on public good, stating that you can't rezone a specific property to benefit that property owner unless there's a public good. Every single property in this county that gets rezoned benefits that property owner. This rezoning would create 1 more house for housing stock. Every lot that does that creates 1 more house. In an area that's 1/10 of a mile from a school, I'd say that's a good thing. To say that this doesn't create housing stock, which is sorely needed in this area, and I'm not going to sit up here and tell you that it's affordable, probably won't be. There's other areas of the county where affordable housing is happening. If public good is not creating more housing supply in an area that's sorely lacking, I don't know what is. Sure, it may be 1 lot. That's all they can do. They had 40 acres, maybe they'd go for more. Maybe they go for 8 lots, 16 lots, but they don't. They have 5. I also would highlight, I feel like the attorney really brought the scare tactic to you all, talking about spot zoning. There's nothing in your criteria. Matter of fact, your criteria are, if you find in favor of those 4 criteria, as I've outlined, that guarantees it's not spot zoning, because those criteria were drafted to make sure that you don't approve of spot zoning. That's why you have those criteria. The criteria in front of you today are not state statute. It's not court rulings. It's your criteria, which your attorney has said, if you make these findings, it's a viable rezoning and legally accomplished. I would like to read for you the definition of compatible from the Land Development Code. Compatibility. Compatibility, the characteristics of different uses, activities, or designs which allow them to be located near, not adjacent as the neighbors are suggesting, near or adjacent to each other in harmony. The slide I put up before showing the land uses that are allowed in the 2 different zone districts, that's harmony. Other important characteristics that affect compatibility are landscaping, lighting, noise, odor, and architecture. None of those are issues here. At least I didn't hear any from the neighbors, and I don't see any myself. The most critical part of this definition is the next line. Compatibility does not mean the same as. It does not mean 5 acres where there's 5 acres. It doesn't even talk about density. It does not talk about lot size. It's really more referencing how you use the property. And the use that's being proposed is single family detached. Everybody that got up and spoke, I'd be willing to bet my life savings, they all live on single family detached. No different than what my client's proposing for the new lot. That's compatible. It goes on to say, rather, Compatibility refers to the sensitivity of the proposed use, not the proposed lot size, the proposed use. Activity or design to maintain the character of existing development within the vicinity, not next door, in the vicinity. As we've identified and frankly acknowledged by the neighbors, Flying Horse is in the vicinity. It's closer than most of the people that got up and spoke. 2.5 acres, you could almost argue is incompatible with that, but it is the transition, right? That's how we get from urban level development to the rural areas of the county. I have a lot of notes and there's a lot of scribbling. It's my law school hand. Somebody brought up the issue, I think it was the attorney again, brought up the issue that with R 2.5, you don't have a maximum building coverage. You don't need one. That's what the setbacks are for. I think even the attorney said there's no limitations on height. Of course there is. Look up the dimensional table in your land development code. He somehow made drew the conclusion that all these accessory dwelling units are limited by height and somehow our 2.5 lot is not. That's factually false. Look in your land development code. I don't have it in front of me, otherwise I'd bring it up. John, the realtor, sorry, I again didn't get his last name, I apologize. He said Mr. Lubitz cannot subdivide. Mr. Lubitz gets his property rezoned, he can subdivide. Again, factually false. Mr. Davis, appreciated some of the comments he made on his well. I think he even acknowledged that his well was his problem. It's not a result of the drawdown of the aquifer, which is happening, of course. But that's not my client's responsibility to deal with that. But he identified that their covenants allow second dwelling. And I'd like to also highlight that the Overlook State's covenants allow for 1 acre size lots. This was something that was done in 1960, excuse me. Even in 1960, they foresaw the possibility that these lots could end up smaller than 5 acres. Explicitly allows for lots down to 1 acre in size. In the legal world, we call that express notice, or at least implied notice, to all those property owners in that neighborhood. And they all bought property knowing that their covenant said that. At no point during the neighbor's testimony did you hear anybody say, I can't stand to see that imaginary line. The reason why is because you won't see it. The structures will look exactly the same as all the other lots that have one house and an ADU that frankly is the size of another house. Visually, it'll look exactly the same. And actually, I would argue that my client's second lot, which will be to the west, again, which will be down gradient, it's going to be largely hidden. The one across the street is up on the hill. There's nothing blocking that. And if there is an eyesore, it's probably that one in the neighborhood. I want to go back. Mr. Stoka, I appreciate Mr. Stoka attending on behalf of Black Forest Lands Committee. Mr. Stoka did oppose the R 2.5 allowance in the master plan when the county took the master plan to the Planning Commission for adoption. He's opposing it today. However, earlier in this same hearing, when it came to the Petrick ADU or second dwelling, he highlighted and championed that the master plan said it should be minimum 2.5 acres. So you can't have it both ways. Either you're for 2.5 or you're not. I think that's fair. You can't shift in the same hearing and say, I'm against 2.5 or I'm for 2.5. That's exactly what Mr. Stoka did in this hearing. I'm glad I came early and I'm glad I listened to other items that were on your agenda. Mr. Byerly, who lived on the north side of Poco Road, who spoke in opposition to the Janes project. I quoted him as saying, "Keep higher density on the other side of the ridge." I showed you the ridge. I showed you the transition area. That's exactly what's happening here. I thought that was well said. Keep it away from where we can see. That's exactly what's happening. It's already happening with all the properties we highlighted in orange. Commissioner Gonzalez, on the Janes sketch plan, you emphasized the transition. This is the transition. This is what we're talking about. This area in yellow is providing that transition. Transitions are important because if it doesn't happen today where there's conflict, it will happen. It'll happen tomorrow, it'll happen next year. There will be conflict. As the city continues to develop and all that traffic goes on Old Northgate, there's going to be conflict and you're going to be asked to deal with it. You transition by allowing slightly higher density in between urban and rural developments. Commissioner Geithner, you emphasize the right to consider the rights or the importance of considering the rights of the property owners on the Janes sketch plan. I think it was well said by the neighbors. My clients don't have a right to rezone, but they have a right to apply for one. And they have a right to try to implement the county's master plan. The county is leading, right? You're not responding to this. You're leading this by saying 2.5 acres is appropriate. That went through years worth of scrutiny. And the Planning Commission supported that. I was not involved in this project, Planning Commission. I'm shocked at what the Planning Commission did because it was them who said 2.5 acres in this area is appropriate. There were some other traffic concerns that were brought up. I mean, we're talking about one lot, right? You just reviewed the Janes sketch plan that had hundreds of lots. I don't think the word traffic came up one time. And we're talking today at this hearing, we're talking about one lot. And I would submit to you, based upon the uses I put up earlier, I pulled some of those out. My client could do all of these uses. And I will guarantee you that every single one of them will produce more traffic than one single family residential lot. So I went back and I listened to the early assistance meeting. As I said, I have not been involved in this the whole time. My former relationship with the county, very interested in seeing how staff did. This was after I left, actually, this early assistance meeting. At no point in that meeting did the county staff identify any issues with this proposed rezoning or subdivision. As a matter of fact, they applauded my client for taking the initiative to make sure that they have their decreed water rights. Sort of unheard of. I've been around a long time. People don't do that. It's a lot of money. They did that to make sure that they had everything buttoned up. They made their submittal to the county. And you all have been around long enough, you know that hardly anything gets through on the first review, right? This did. There was not one comment from county staff. I think there was a slight change to the application form, which is just, basically administrative. Not one comment on compatibility with the master plan. Not one comment on compatibility with the neighbors. That should tell you something. Your planning staff, which does this every day, basically said, this should be consent. Sure wasn't. But all of that was informed based upon the Tri-Lakes plan that I showed you. This has been talked about for years. This isn't new. My clients aren't creating something new, right? This is something that the Board of County Commissioners in the past has already approved. Planning Commission approved unanimously. Similarly situated property. Why is this one different? Why is it different to the extent of getting comments from people that are 2 miles away? It's not. Where were those people when that property got rezoned? There wasn't one. I went back and looked at the minutes from that Planning Commission hearing. Not one person showed up in opposition to that other R 2.5 rezoning. Not one. We have 50 or 70 people here. What changed? The only thing that changed was the development of Flying Horse Ranch. And if anything, that suggests that this is more consistent with the master plan and with all the other uses in the area. Not the other way around, as the neighbors would have you believe. Your assigned planner during the early assistance meeting, and I quoted this, said, "You are doing what you are doing exactly aligns with the land use according to the place types." Exactly. Not sort of, or you're going to have to sell it to the board. Exactly aligns. I want to bring my clients up, Jenny and Steve Leibowitz. They've been pretty affected by this, as you can imagine. I mean, when most of your neighbors come out and say pretty hurtful things, it's tough. They love where they live. I'm gonna have them tell you that. But I wanted you to hear from them, not just from me. So I'm gonna have them come up now, if that's okay, unless you have any questions for me.
Commissioner Geithner.
Thank you, Madam Chair. I do have a couple of questions. And this is going to be, I guess, somewhat subjective, and maybe the owners can answer this as well. To give, I guess maybe some benefit of the doubt here to your statements on what you seem to be characterizing, and feel free to correct me, as an irregular response, perhaps, to this application in comparison to other ones that you're mentioning. Is there anything that you are aware of that you are attributing that response to? Because I'm trying to understand if this does indeed seem to be a regular type application that has happened in the past. What do you attribute the outsized response from neighbors to be?
One thing that stands out to me, Commissioner Geithner, I appreciate that. I think that's a very astute comment or question. This slide shows you the property. If you look, you can see the adjacent properties, right? Standard notice provided by county staff would be to all of the adjacent properties. That includes the folks, you could argue this one, probably not. It would be these two, this one, and this one. That's who should be getting notice of the hearing. Even if you expanded that, as Ms. Harrington implied, you're moving towards to 500 feet. So adjacent, we have eight property owners. If you move to 500, that's 12. There were 19 notices sent out. I don't know why. But it certainly implies that there was at least a desire to provide broader notice than you would normally provide. To what end, I don't know. But you definitely got into the neighbors that are over the hill. And if I get one of those notices, I've gotten them in the mail, it's pretty alarming. And I think that's what generated most of the opposition, quite honestly. And if you look at the letters, and this is an important point, I know of at least one property owner that submitted 3 letters. So when they talk about how many letters in opposition, yeah, of course there's opposition. There's going to be. But I don't think it's 150. And a lot of those are form letters. And you can give them whatever weight you want. I don't give them much, because if they were that interested, they'd be here or they'd write their own letter. But I think this is what caused a lot of that. And I'm not trying to throw your staff under the bus. I just don't have an explanation for it.
Thank you for that answer. I also have another question. One of the things that we're talking about here is compatibility, and there have been comments about expectations of neighbors and several of those things. But you just mentioned in your rebuttal the covenants that suggested that there would have been some reason to believe that the lot sizes could be reduced. So I have a couple questions specifically about that. Number one, I'm still a little bit confused about the neighborhoods that are mentioned. So Overlook Estates has been mentioned, and Sun Hills. Is this site in one of those 2 specific neighborhoods?
It is in Overlook Estates, which is the 14 acres here, or excuse me, 14 lots here.
Okay.
Sun Hills is up in this area.
And so it is specifically in
Overlook Estates.
the covenants of Overlook Estates, where this site is, that this property owner, I guess we could say theoretically believed he had a right to consider doing that by coming here to this board. And that was shared with all of the lot owners. Do you have, not to question your integrity here, but I'm hearing this is the case. Do you have a copy of those covenants? Do you have something that you could show us that that is the case? That would just be of interest to me to actually see those.
Sure. I think we can probably produce those. I didn't provide, they're kind of hard to read, honestly, because they're so faded, because they're pretty old. We'll see if we can produce that for you. I did want to touch on that. You know, I think you hit it on the mark. Somebody said that you don't have a right to use your property to the most profitable extent possible. I heard that said. Doing 1 acre lots would do that under the covenants, right? Not 2.5. 2.5 doesn't do that. Or frankly, utilizing any of the other land uses I identified. You're gonna make way more money converting it to a tree farm or a large scale greenhouse than you are splitting it into 2.5s. So I found that comment was pretty unfounded, because if you look at the zoning, there are a lot of other uses that are a lot more profitable that you could implement than just splitting it in half. We're working on it. Any other questions for me while they're looking for that?
Any other questions for the applicant? And sir, it looks like you're standing back there to make a comment, but we're in a public hearing process, and this was the applicant's rebuttal opportunity. So you've had your opportunity, and I'll have you. If I can have you take a seat, and we're going to continue running through our process. Thank you, sir.
Nancy, can we get the overhead, please? Whoever's up there. There we go. This allows for rezoning of a portion of the subdivision by the zoning authority, which is you, to go down to 1 acre lots.
Thank you for providing that.
Any other questions for the applicant?
Ms. Chair, if I could bring my clients up, I'd like for them to speak, and if you have questions for them, it'd be a good opportunity for that.
That'd be great. Thank you.
I just ask that comments be as part of the rebuttal process.
Correct.
Thank you.
Correct. This is the applicant and the applicant's representative on rebuttal.
Hi, I'm Jenny Leibowitz. It has been a little nerve-wracking, so excuse me if I'm not quite as articulate as maybe some of the other people. It's a little emotional for me. But I wanted to give you a little bit of history. We've lived in Overlook Estates for over 20 years with a very short stint away. In fact, we built the home at 1820 Old Northgate Road originally, and it's adjacent to where we live now. It used to be actually 1820 Northgate, because they changed the name of the road once Flying Horse was developed, which was after we moved in. So needless to say, we have seen substantial change in our neighborhood, even from back then. We watched Flying Horse development begin, as well as Discovery Canyon School, which was right across the street from our property. In fact, my husband was on the committee to try to mitigate the effect of the school on the area being right across the street from us. We sold that property in 2012, thinking that we would downsize, but soon missed the rural area, and we purchased 1825 Summit Drive. This home was a fixer-upper, and we are proud and feel a great deal of satisfaction of the improvements we have made both inside and out. We are constantly improving our property. We love it there. We gave a lot of thought before embarking on this rezone. This is our forever home, And we wanted to be sure we would maintain the rural residential character of the neighborhood should we do something like that. The way our home is situated does that. We also made sure that what we planned to do would fit into the master plan of El Paso County, which it does. Talking though a little bit more about where our house is located, we're on the far northeast, like barely just at the very, very top of the corner, which maximized the view of our home. The next property to the west of us is on the far north. Let's see, we're on the northeast, they're on the northwest parts. There's essentially almost 10 acres between us. Where we would position our home was down more in a valley in between those two. We felt it had very, very minimal impact, not only on our own property, but on anyone else's property in the area. We did give that a tremendous amount of thought. So because we felt like we were in accordance with the master plan, we decided to exercise our property rights to ask for a rezone of our property. And regarding this process, it has been extremely expensive. We had no idea we would be spending at this point over $25,000. That is not recoupable in order just to get the rezone, to get to today, basically. And obviously we lose it if it's not approved, but obviously that was a risk, but we took that risk because we felt like, according to our EDARP meeting and planners along the way, that we were in accordance with everything that we were required to be. We were never told we could be denied due subjective criteria, such as neighbors not wanting change. That was never brought up. We even asked in our EDARP meeting, what if neighbors don't really want it to go down to 2.5? And they said, as long as you're fulfilling your criteria that is necessary for a rezone, you should be fine. So we proceeded forward. I don't know if we would have moved forward knowing we were going to be spending $25,000 and had a huge risk of being denied. When the official reason our application was recommended for denial, the official reason that was stated to us in our paperwork is that we had not shown substantial change in the area. But I really have to question that. We have the entire Flying Horse development that I look at every single day from my back deck. We have a school of 3,000 people that come and go every single day, along with the traffic from Sun Hills coming right past our property. I know you consider ADUs a little bit different, but in comparison to one residential property per even a 2.5 acre lot, there are many ADUs in this area where they're right next to each other. They're huge homes. In fact, directly across the street from us, they received a special waiver to have a huge house built right next, or on the same area that the original house is. We see that from our property. And yes, there is no dividing line where they can actually sell those properties separately, but they are certainly being used as what many people are fearful we will use our land, which is a second property. We also have high-density housing that we can see from the corner of our lot. They are less than 1/3 of an acre. If you look down at Flying Horse at the corner of Old Northgate and Silverton, those are house. It is a high-density subdivision that we see from our lot. That is substantial change to me. Regarding our neighbors, we have always been very transparent and upfront with our neighbors on Summit and our cul-de-sac regarding our wish to rezone. Someday. We never said when, we just said we would like to do that if we could. We never received feedback. We never received discussion or opposition during the times that we mentioned it to them. In fact, some said in their letters of opposition that they would actually do this also if they could. And in talking with one of our neighbors, says, I might want to do it someday. So there was no opposition to our knowledge. We even called them personally in our cul-de-sac prior to adjacent letter notifications going out, prior to spending additional funds. no words of dissent, then either. So imagine our shock and dismay to find out about the opposition that Sun Hills, who are not even adjacent property owners or even in our subdivision and are over a ridge and down in a valley, orchestrated a huge campaign against us. Extremely nerve-wracking and upsetting. And that came in just 2 weeks before a planning commission meeting after we had already spent a tremendous amount of money on this. Apparently the county had sent out 19 or 20 letters, which it was our understanding we sent 8 to our adjacent neighbors, but 19 or 20 went out, which included some Sun Hills people. My final thought here is that Sun Hill residents don't seem to mind their subdivision exercising their rights to change their neighborhood. The amount of ADUs are examples of that. The very people opposing us either have them themselves or are very nearby to an ADU or additional home to be used for guests or even permanently for family that you may not even know about. I know for a fact there are people in our area that are using their ADUs permanently for family as separate residents. But yet they're opposing us who want to do the same, which would include a subdivide and a rezone, which of course that means that we could sell our property, but that is the only difference. The usage, which is what they're complaining about, is already there on multiple lots. Our rezone and subdivide would not look much different. In fact, I think it's likely better than a lot of those, considering we have so much space from where the new house would be. And it is still very rural. So I appreciate your time and consideration for us to rezone and thus continue to use our property in accordance with the master plan of the El Paso County and keeping it rural residential, which is what we're asking. So thank you for your time.
I was going to say good afternoon, but it's good evening. My name's Steve Leibowitz. I've been a resident of El Paso County for 63 years. My career focused on protecting the rights of the citizens of the Pikes Peak region for over 30 years as a first responder with the Colorado Springs Police Department. I started off a long time ago as a young patrol officer. I rose through the ranks, had a variety of jobs, and I retired as the Deputy Chief of Police. I became a trusted community leader who believes in the rule of law, and I continue to live my life as a rule follower. My wife elaborated that we've been property owners in Overlook Estates for over 20 years, and that we did advise our neighbors of what our intentions were if we had an opportunity to subdivide. So I'd like to take some time now to provide you a private homeowner's perspective on what it's like following and complying with the process. In the spring of 2021, we were advised that El Paso County had modified the master
Madam
plan.
Chair, this is supposed to be rebuttal, and that's all I'm going to make as a statement. Thank you.
Thank you. I believe if you could keep your comments, you're welcome to continue. Keep your comments somehow addressing something else you've heard in the hearing today.
Okay. So I can't talk about the process that we had to go through and the issues that we had to endure.
Again, ma'am, there's a process. The process I believe we're in is the rebuttal process. Those comments are supposed to be in response to issues that have come up during, and unless I'm hearing it wrong, so maybe our attorney can tell me. So I'd ask for some clarification. I'm not trying to cut you off, sir,
Okay,
but
we'll take a brief recess, sir, and be right back.
take back anything I said. Thank you.
We'll come back to order. You know, we do have process that protects applicants, that protects our code, and we try to stick to it. And that being said, we would like to hear what you have to say. If you could complete your comments, and we'll continue.
Okay. My comments are basically around the premise that I've been a rule follower my whole life, and we have no need to have an ADU on our property. So going through the rezone process and following the rules that are in place is important, and that's part of what I wanted to bring to your attention if I could continue that. Okay. So in 2021, we were advised that the master plan had been modified and that if we could get water rights for a second property, that would streamline the process and would help our goal to rezone. So going through the expense of the rezone and a mini subdivision didn't make any sense at all to us if we couldn't get a second well permit. So we did spend a significant amount of money working with water attorneys and the state of Colorado water engineers to look at the ability and the availability of securing a second well permit. They conducted a almost year-long extensive analysis, and their final recommendation was that there was ample water for us, and that was provided to the Colorado Water Court. And last summer, they agreed and they gave us our water decree. At that point in time, we were ecstatic, and we said, okay, we've got the big part of this thing behind us, so we wanted to proceed with the rezone process. So on July 12th of last year, we had our early assistance planning meeting with what I would say is the first of 3 different project managers from the planning department. The first one was Matthew Fitzsimmons. So that $400 1-hour meeting was recorded on a Zoom call, and it's on our eDARP file. And I would encourage everybody here, if you get an opportunity to kill an hour, to watch it. It was very enlightening. So he was assisted by another planning department employee. They provided us a step-by-step guideline, gave us the application process. And when we told him that we'd already secured our water, they were ecstatic, absolutely ecstatic, and said that that was a huge part of the approval process during our discussion. Also during that 1-hour meeting, which is recorded, Mr. Fitzsimmons said that the rezone is a fairly simple process. He stated, quote, "I believe you meet the final criteria." We talked about the master plan large lot residential place types, and he said, quote, "You are well within your rights." That our proposal, quote, "exactly aligns with land use." At no time were we ever told that this was a subjective process. We were led to believe it was an objective process and that we had already completed the biggest challenge by securing our water rights. At no time during this process did Mr. Fitzsimmons identify any potential issues or concerns. In fact, it was quite the opposite. The overall tone during our meeting was positive and optimistic. He did recommend that we hire a professional engineer to help us, which we did. So we ended that meeting feeling very upbeat. What was shocking, my wife alluded to it, was the associated costs with this process. I mean, we're not, a big money developer. We were looking to do it as a single property owner, and the cost that we were having to pay out of pocket was shocking. It's a big hit for an individual property owner trying to only create one lot. But again, we were led to believe that this was an objective process and we had nothing to worry about. January 6th of this year, the eDARP file shows that our project manager, Mr. Fitzsimmons, was replaced by Christian Haas. At no time were we even advised of this, what I consider a significant change. January 11th, the EDART file documented the assignment of Lakeisha Bellamy as our third project manager. On March 7th at 8 in the morning, Lakeisha called me at home advising me that she needed some minor changes to our application. Told her I'd pass that information on to our engineer. I asked her if there were any concerns or issues, and she responded that everything was submitted and that we didn't have anything to worry about. Again, our third project manager reaffirmed there were no issues and no concerns, that we didn't have anything to worry about. On February 24th, I received an email stating that we had to do the notice of public hearing posters, which I responded. I posted to them, took the pictures, and on Monday, March 2nd, I drove down to the planning department to get the notary paperwork signed off. At that time, I decided to reach out to Miss Bellamy again to see if there had been any other changes. And she advised that there was some limited opposition to the rezone, but again, said everything would be okay. This was the first minor issue in this entire 8-month process that was brought to our attention. So at the beginning of the Planning Commissioners meeting, several planning commissioners focused on the fact that the county did not have a record of a driveway permit fee for our property. I think that's like $200. Some of the commissioners made us feel like we had done something illegal until it was brought to their attention that the county didn't even begin collecting those fees until after our house had been built. When the commissioners then began hearing citizen opposition, they allowed repeated input that focused on issues that weren't even related to the review criteria for a rezone, such as precedents, land values, and water. As a result, it became very apparent to us that several of the commissioners were already pre-convinced to rule against our request. And I sat in utter bewilderment listening to the commissioners' vote of denial. For 8 months, we followed the department's application process to the letter. We were told our application was complete, there were no issues, there were no concerns, and that our proposal exactly aligned with the master plan, and that we had nothing to worry about. We paid out a significant amount of money. We were positive and optimistic that the process would be objective and fair. Since the Planning Commissioners meeting, we've been in total shock that the commissioners didn't follow their own master plan, but listened to the misinformation campaign orchestrated by the Sun Hills Homeowners Association. Yesterday morning, I received a call from our planning department project manager. During the conversation, Ms. Bellamy related that we, and I'm just assuming we meant her department, were shocked that the Planning Commission had denied the rezone request, especially since we had met all the review criteria. Ms. Bellamy then stated she hoped the county commissioners would approve our request at today's meeting. For 8 months, your planning department project managers, who I consider are experts in this field, have repeatedly and continue to tell us that we meet the county's final review criteria to rezone our property from RR5 to RR 2.5 per the master plan. I firmly believe in an individual property owner's rights. I believe our rezone request to allow for a single rural residential lot is consistent with the rural residential character of our neighborhood, which already has experienced substantial change the past 20 years. As private homeowners who diligently followed your process at a significant expense, we respectfully ask you to approve our rezone request. Thank you.
Thank you. Any closing comments?
Thank you, Mr. Chair. The only other item I wanted to bring up, there is some text in the staff report that states, and this is assuming that you approve this today, I want to make sure that the record's clear, states that in order to initiate any use on the property, there's a requirement to get approval of a site development plan. Site development plans are required for commercial and industrial users, as well as multifamily. I'm assuming that's a typo and not a requirement. The requirement for single-family homes is a site plan, which is an over-the-counter process. So I'm assuming that was a typo. If it's not, I would like to discuss that further. That requirement should not be placed on any lot that's zoned residential for residential purposes. Other than that, Mr. Chair, I'd be happy to answer any other questions.
That being said, that last point that you had is that I'm assuming there is some type of process for submitting the plan for the actual subdivision and then subsequent placement of another residence and all the codes and things that go along with that.
Correct. They'll be required, if it's approved, to go through the minor subdivision process, or I think since this is plat, it could be an amended plat. So that'll be a subdivision process. As you all know, that is a very objective process if you meet the black and white requirements. And then in order to construct on the property, you're going to have to get a site plan for single-family residential, and you'll have to do your stormwater permit as well.
So there is a site plan. It's just not a site development plan.
And the significance there,
as a
site development plan brings
developer would
in,
have.
sorry, excuse me, site development plan brings in landscaping, lighting, parking, all kinds of stuff that is not applicable here. That concludes our presentation.
Okay.
Any questions for me?
Any questions?
No.
Commissioner Williams?
I just wanted staff to come back up and have a question for them.
Yes, Commissioner.
Yes, Lakeisha. Could you bring up the staff presentation again that has the review criteria? It's the easiest thing.
And actually, I'll go ahead and declare the public hearing part of this closed, and you can ask questions of staff still.
So I will say, as the resident commissioner, I don't think I have any questions of staff, but as the resident commissioner, I think that this application doesn't meet the criteria. And I say that because I don't consider this substantial change in Flying Horse North to be something that was under our control. And so with that comment, and I look at this area, I'm familiar with this area, and I was surprised that someone was coming in to ask for rezoning, because I had not remembered in past history that had happened, except for, I guess, Mr. Wolf came in and asked that his be subdivided into 3 5-acre lots. I do think that the surrounding zoning is in 5-acre lots. And I do think that the items that I have specifically approved have been accessory dwelling units for either the elderly or a handicapped child. And so for that reason, I would make the motion to not approve this application, deny this application. Let's get that started right off.
I'll second.
All right, there's a motion and a second. Is there any discussion on that motion? Commissioner Geithner.
I actually would like to look at the master plan place type that was described in the presentation. I don't know if you need to advance it or if they can do it.
I think it's slide 10, the next one. Yeah, slide 10. Or 9. Do you have any further questions, Commissioner Geithner, on that? And is that the slide you wanted, or was it slide 9?
I think that sufficiently, what I was looking for was from my compatibility and conformance with the master plan was looking at what that specific was. So that does answer my question because it specifically references the 2.5 acres. Thank you.
Any further discussion or other comments on this item? Commissioner Geithner.
Thank you, Madam Chair. This is a really difficult one, and to be honest, one I didn't anticipate. What we do here is obviously based on criteria, and it is difficult sometimes, as we talked about in other hearings and other times today, the process that we have here with having going back and forth between those who support and those who oppose is really helpful to kind of getting to some of the details that we need to make that decision. I do believe this is in conformance with our master plan because it specifically says 2.5 acre lots or larger and that large lot residential. So I do agree that it is in conformance with our master plan, which is a little bit difficult. To be honest, there was a huge question for me on why you would rezone a lot in a neighborhood. The realization that that seems to have been contemplated since the beginning of the neighborhood was quite surprising, and is most certainly weighing into that understanding as well there as of what was anticipated for this area and what has been planned for this area. And so that has been very surprising to me. I think that is a piece that is quite frankly a little bit of a game changer for me. There are two things that I have heard that I'm trying to align with our criteria here. One is the spot zoning commentary. But I do feel like that is not. I mean, while the arguments presented are important, I can't say that I can agree with that particular argument. The other one, the majority seem to be about a slippery slope of rezoning things, but that is not a piece of our criteria that I can, in good faith, consider. It is most certainly allowable to our master plan, and while I would agree that we didn't make the changes of Flying Horse, that doesn't. The question is, has it changed? And it doesn't say changed by us; it just says changed. And so I actually think that it meets both of those pieces. As I said, this is a very surprising one for me, but I find that I cannot find any reason that this has not met the criteria.
Commissioner Gonzalez.
Thank you, Madam Chair. What it came down for me and was referenced earlier, was like, oh, we heard you talk about the other one. Well, there was already precedent on the other ones of the similar type change. In this case, all the changes that were noted were ADUs, not a splitting of the zones for those properties that were brought up. So I thought it was different, and that's why I didn't think it's compatible. That's why I don't believe it's compatible to the surrounding areas. I did want to clarify because, I didn't mean to show any effort to try to discourage comments from the applicant. We have a process. One gentleman tried to come up from the public who had already spoken. He was not allowed to speak again because the process was you speak, and then that time to speak is over. That's why we ask that the applicants that come in afterwards, when we say rebuttal, is you're addressing the issues that have been brought up. When you bring up new issues which were brought up, you're almost opening it back up to allowing public to come back in and rebut your rebuttal because it wasn't a true rebuttal. It was new information, a lot of the processes. And that's why I spoke, because now we're not allowing others to come up on new information. So that's why I made those statements, not because I think clearly applicants should get as much time as they need to make their arguments, but I thought they were bringing up new information that the public could not then respond to. So thank you.
Thank you. Commissioner Vanderwerf.
Yes, thank you, Madam Chair. I want to thank everybody that came here, from the applicant to the citizens, to discuss, as it turns out, something that seemingly seems so simple, but actually is pretty important regarding, I think, in my humble opinion, the future direction of the county and land use. It's funny sometimes how this plays out, where it just on the surface might not seem like such a big deal, but actually could have an impact in what the county does going forward, or also how the citizens would behave towards the county, going forward. So first off, I do want to thank the applicants, the trials and tribulations that you've been through, the challenges that you've had. Boy, I don't wish that on anybody. I appreciate your service, sir, as a law enforcement officer. But I do have a concern, and that is, once an area is developed, I just do think a very judicious use of rezoning should be considered. In the process of starting a development or developing a large land area, I think there's a different treatment there. And I mean, I'm a huge fan of private property rights. I really am. And I am a huge fan of allowing for more housing stock to be built in the county, because there is a gigantic demand, and it is my firm belief that the best way to deal with housing demand is to deliver supply instead of having government try to direct it to you. But in this particular case, I am concerned that we could set a precedent, really, really cause a problem. And to some of those comments, first of all, to my fellow colleagues, boy, thanks for sticking it out on this. And this is not, I think this is not a simple decision. And I can say with certainty that a 2.5 acre versus a 5 acre, those are certainly have a lot of similar characteristics and a lot of similar land use rights and so forth. Certainly much closer than if you were to go down the path and zone an area a particular way, and then 20 or 30 years later, somebody wants to take, a 5 or a 35 acre lot and turn it into an industrial zone. Those are some pretty big changes. But having said that, there are still differences between the 2.5 and the 5 acre. And those include, and they were displayed, but on the 5 acre lot, there are these other uses that are available. So boy, I've debated internally in my mind, kept my counsel to myself, and listened to the testimony. But I do feel that we should be very, very judicious in the use of rezoning after a community is fully developed. So I will vote to support the motion from Commissioner Williams.
Commissioner Williams, any comments?
I would just say both of my colleagues said the arguments summed them up so well, from Commissioner Geithner's comments to Commissioner Vanderwerf's. This has been a very long day, and in my mind, when I had heard about this zoning coming through, the rezone, the first thought in my mind was it just does not fit the character of the neighborhood. because I know the neighborhood there. And in this case, I do wish circumstances were different because you have done a lot of work, including getting the water rights, which is just nothing short of a fantastic effort on your part and speaks well of those who are representing you. Thank you.
Can we get the criteria slide back up, please? Looks like it's slide 14. Any other comments? I agree. This one's really difficult. We have a former colleague who used to say the hardest part of this job is we're in the difficult position of adjudicating where one property owner's property rights start and end and where another's start and end. And for the most part, we rely on criteria to guide us through those decisions. And like my colleagues have said, sometimes it's just not that easy. I am also fairly familiar with this area. I have friends who actually live right there as well. I think, we have the opportunity to review the, not just the recommendation from the Planning Commission, but part of our due diligence is to really read through the transcript and understand why and what was said and which commissioners, brought up different things, because everybody's going to look at a difficult piece like this differently. And one of the things I thought rather astute as well was Mr. Carlson made the point, similar to Commissioner Vanderwerf's point, that it's entirely a different thing to consider an already built out neighborhood a transition area and go back in and change it. This one's tough because I, too, believe strongly in property rights, private property rights, and the ability for an owner to dream and imagine what they would like to do with their property. So many times we have people who don't go through the process and still do it anyway. So, preserving the integrity of that, that there is a process, and there's the criteria. This one, to me, honestly seems just really difficult, really difficult to force into. I think Commissioner Vanderwerf's words were very strong as well, that we must be judicious. And I don't believe that it's in conformance with the master plan. So with that, any other comments? Commissioner Geithner, do you have any more?
I just have a question, because I do think this is a very difficult one. I would ask genuinely for if there are comments on how this is not in conformance with the master plan. I would love to hear those, because I am struggling with it specifically saying 2.5 acre lots on our master plan. So I would just ask for help from my colleagues on this one, on your thinking on that, that might benefit my thinking as well.
My statement that it did not comply with third point.
On the first rezoning criteria. The application is in general conformance with the El Paso County Master Plan, or there has been a substantial change in the character of the neighborhood since the land was last zoned. I am not seeing the substantial change in the character of the neighborhood. I do understand that Flying Horse is just half a mile south of this, but I know Glen Eagle is about 2 miles to the west of this. And just up on Baptist Road, you have the town of Monument. So you have high density all around. And I've just felt that even for the 30 years I've lived here, everybody has known this area to be 5-acre lots. I mean, not everybody. I shouldn't say everybody, because not everybody knows this area is 5-acre lots. I have always known this area to be a 5-acre lot. The very first time commission meeting that we came into that was a planning commission, I think we considered an accessory dwelling unit in this exact same neighborhood. And I struggled with that one as well, because I do think it is very much a 5-acre lot neighborhood. And that is what I'm really relying and making my decision on, is that in approving this, we will have other 5-acre lots come in and ask for a rezone as well. And so that, I think it changed the fundamental zoning of the neighborhood. And honestly, I do not know if I'm right or not, but that's where I am at.
And to my colleagues, since the question was asked, I'm happy to provide my my thoughts about that as well. And I do believe that it is in violation of item 3 that's on the rezoning criteria, as again, as difficult as this is. But all of the properties surrounding this property are zoned RR5. And there is a change difference in land use rights between RR5 and RR 2.5, as was illustrated in the testimony today. So I think it does actually change. And again, you can make the point, it isn't as big a change as, say, if someone were to ask for a rezone to an industrial center, but it still is a change. And I don't believe it meets the criteria of item 3.
Commissioner Cotton.
Madam Chair, I would ask for a brief recess to conference with our attorney, please.
Okay, we're in recess. Okay, once again, I will call this meeting of the County Commissioners Land Use Meeting back to order. And we were in discussions. A motion had been made and seconded. Is there any more discussion or questions needed? Okay. With that, I will call the roll. Commissioner Williams.
On the motion to deny the application, I will vote aye.
Commissioner Vanderwerf.
Aye.
Commissioner Gonzalez.
Aye.
Commissioner Geithner.
Nay.
And the chair votes aye. In a very difficult vote. That is 4-1 to deny the application. Just a few closing comments on this item. I too want to thank all of you for coming today. I want you to, maybe you've seen how seriously we take all of this today. So thank you for your time. Thank you for your patience. It was a big and long day. We appreciate everyone's input, everyone's effort, and thank you. We are on item number 9.
Item number 9 is department and committee reports, non-action items, and there are none.
Item 10.
Item number 10 is the addendum, and there are no addendums.
Item 11.
Item 11 is executive session, and there is no request for executive session.
This meeting is adjourned.